to the final round of mock trial. We're all excited to be here. Ready to go? Okay, before we bring out our presider over the trial, I'm going to introduce you to our scoring attorneys that we have here tonight. I want to introduce you to Judge Jacqueline Jackson. She is our presiding judge here in Riverside. Our next scoring attorney is Megan Dembski. She is the president-elect for the Riverside County Bar Association. Our next scoring attorney is our county public defender, Steve Harmon. Our next scoring attorney is the lead of our conflicts panel out here in Riverside for Jamie Blumenthal. And our next scoring attorney is Assistant District Attorney Jonna Key. I hope you all have a fantastic round, and I wish you all the best of luck.
All right! Superior Court of the State of California, County of Riverside, Department 1 is now in session. The Honorable Judge Sykes presiding. Please be seated and come to order.
Thank you. Welcome, everyone. We're here for the case of People v. Gold. Is each side ready to proceed?
Yes, Your Honor, but before we begin, may the people please state our appearances.
Yes, go ahead.
Thank you, Your Honor, and good evening. My name is Isaac Julian, and I will be opposing the pretrial motion on behalf of the people of the state of California. May the rest of the prosecution team please introduce themselves.
Yes, go ahead.
Good evening, Your Honor. Jonathan Bion, for the people.
Good evening, Your Honor. Aubrey Packer, for the people.
Good evening, Your Honor. My name is Sydney Smith, and I am Ali Sandoval.
Good evening, Your Honor. My name is Beckett Sullivan, and I am Taylor Alexander.
Good evening, Your Honor. My name is Connor Julian, and I am Deputy Riley Kim.
Good evening, Your Honor. My name is Samuel Beaumont, and I'm Dr. Ray Forrest.
Good evening, Your Honor. My name is Acacia Bernier, and I'll be the courtroom clerk for tonight's proceedings. May I address counsel with the time signals I'll be using for tonight?
Yes, go ahead.
Good evening, counsel. I'll be giving both verbal and visual time warnings of 2 minutes, 1 minute, 30 seconds, and stop. I will also be giving time remaining after the first 3 witnesses on both sides. Thank you, Your Honor. This concludes the prosecution's introductions.
Thank you.
Your Honor, may the defense proceed with introductions?
Yes, go ahead.
Good evening, Your Honor. My name is Grace Mankin, and tonight I will be arguing the defense pretrial motion on behalf of my client, Logan Gold. And at this time, if it so pleases the court, may my co-counsel please introduce themselves?
Yes, go ahead.
Good evening, Your Honor. My name is Anna Sophia Ramirez, and I represent Logan Gold.
Good evening, Your Honor. My name is Sydney Kramer, and I represent Logan Gold.
Good evening, Your Honor. My name is Natasha Singh, and I represent Logan Gold. And at this time, if it so pleases the court, may our witnesses introduce themselves in the order in which they will appear.
Yes, go ahead.
Good evening, Your Honor. My name is Emma Sen, and tonight I will be portraying CJ Costley.
Good evening, Your Honor. My name is Xavier Felix, and tonight I will be portraying Harper DeRay.
Good evening, Your Honor. My name is Madison Mendoza, and tonight I'll be portraying Logan Gold.
Good evening, Your Honor. My name is Min Lai, and tonight I will be portraying Dr. Cody Palmer. And at this time, if it so pleases the court, may our courtroom bailiff please introduce himself?
Yes, go ahead.
Good evening, Your Honor. My name is Jonathan Medrano, and tonight I will be serving as your courtroom bailiff. For the court's convenience and use, I have a copy of the 2025 Riverside County Mock Trial Competition Team Handbook, along with a full copy of the case materials right here pleaded. At this time, may I please go over the courtroom rules?
Yes, go ahead.
Thank you, Your Honor. Good evening, ladies and gentlemen. Welcome to the final round of the 2025 Riverside County Mock Trial Competition. To avoid any disruptions during tonight's proceedings, please adhere to the following rules. Take a moment to ensure that your cell phones are turned off or placed on vibrate. Please refrain from talking at all times. Taking photographs and recording while course in session is strictly prohibited. With the exception of water, no food or drinks are permitted in this courtroom. If you must leave the courtroom during the trial, please do so only between witnesses. When you re-enter the courtroom, please wait until after the witness has finished testifying. Thank you, and please enjoy the round.
Thank you. Are parties ready for the pretrial motion?
Yes, Your Honor, the defense is ready.
The people are ready as well.
Okay, whenever you're ready, you can proceed on behalf of the defendant.
Thank you, Your Honor. The Fifth Amendment right against self-incrimination serves as a shield, ensuring that no person can be forced to provide the evidence that could be used to convict them. My client, Logan Gold, exercised this right by refusing to speak with police and requesting an attorney. Yet Deputy Kim disregarded this, subjecting her to coercion and emotional manipulation, eventually eliciting the statement, "I was trying to make sure the inn could be passed down for generations." As such, the defense respectfully requests that this court exclude Ms. Gold's statement for the following two reasons. One, the statement was the product of a custodial interrogation, and two, Deputy Kim ignored Ms. Gold's invocation of her rights, resulting in a statement that was not made knowingly.
Let me interrupt you for a second, counsel. When your client was asked if they wanted to talk to their spouse, correct, and with the deputy in the room, your client responded, "Absolutely, I want to talk to Harper." Didn't that result in a knowing and voluntary waiver, or was it when your client started talking about other topics after the deputy finished speaking, was that an involuntary waiver at that time? At some point, wasn't there a voluntary waiver?
No, Your Honor, not at all. Now, Ms. Gold did say that she wanted to speak with her husband, Harper DeRay. However, she never stated that she wanted to speak with Deputy Kim, a state actor. Now, after Ms. Gold invoked her right to remain silent, Deputy Kim isolated her for 2 hours. And upon re-entering the room, Deputy Kim immediately began speaking to her with his hand on his holstered gun, telling her not to make her husband complicit in a crime. This absolutely resulted in an incriminating statement from Ms. Gold, but it did not result in a voluntary and knowing waiver of her rights. May I proceed?
Yes, go ahead.
Thank you. Which resulted in a waiver that was not, in a statement that was not made knowingly, intelligently, or voluntarily. Addressing my first point. In Miranda versus Arizona in 1966, the United States Supreme Court held that officers may not continue interrogating a suspect in custody unless...
I'm very familiar with Miranda, but what I want to hear you talk about a little bit is the Musselwhite decision. So doesn't Musselwhite hold that anything the deputy did is tested under the facts and circumstances as to whether it caused the defendant to respond immediately? So in this case, there were some comments made by the deputy. However, then there's evidence that when the deputy was seated, finished speaking, and then your client went on to talk about several other topics, was essentially rambling. Therefore, under Musselwhite, because there was no immediate causation, so no immediate response to what the deputy had said, then wouldn't the court then remove anything the deputy said to determine whether or not the statement was voluntary, essentially leaving the subsequent statement to be a voluntary statement because it wasn't essentially in a direct response to the deputy's comments?
Your Honor, I have to respectfully disagree with the court. Now, when we look to the 1998 United States Supreme Court case of People versus Musselwhite, we can see that the court held that we must look to the totality of the circumstances. Now, when we look to the totality of the circumstances, we have to examine Ms. Gold's prior relationship with Deputy Kim, we have to look to Deputy Kim's comments and actions, and we also have to look to how many times Ms. Gold was advised of her Miranda rights during this interrogation. Now, first of all, I'd like to start off with the fact that this is one of several unpleasant encounters that Ms. Gold has had with Deputy Kim during this investigation. And in Ms. Gold's witness statement, she states that Deputy Kim made her uncomfortable and nervous. Now, here, Ms. Gold was only Mirandized once at her home, which is different from several of the cases in our closed library. And then, after she invoked her right to remain silent, Deputy Kim isolated her for 2 hours before re-entering the room, eventually placing his hand on his holstered gun, telling her to make sure her husband knows everything, not make Mr. DeRay complicit, and then...
Weren't those statements by the deputy almost just comments? So if you look at the Enos case, in that case, the police expressed a concern that the shotgun used in the crime would be found by children, right? And Enos held that those words were not reasonably likely to elicit an incriminating response. Here, the deputy essentially posed a thought experiment using the word, think about honesty in politics. Telling someone to think is not necessarily inviting a response, is it?
Your Honor, the 1980 United States Supreme Court case of Rhode Island versus Innis is factually distinguishable from our own case. Now, in Rhode Island versus Innis, 2 officers were speaking to each other, and they weren't aware that the suspect sitting in the back of the police car that they were in was listening in on their conversation. Now, in that case, the suspect did overhear them, and he voluntarily chose to reveal incriminating information. That is absolutely different from what happened in our case today. Upon re-entering the room, Deputy Kim spoke directly to Ms. Gold. Ms. Gold's following incriminating statement was affected by the words of Deputy Kim, and it was involuntary and unreliable, and therefore it cannot be admitted at trial.
Okay.
May I proceed?
Yes, go ahead.
Now, moving into the case of Rhode Island versus Innis, which we just discussed, the Supreme Court clarified that interrogation isn't limited to direct questioning. It includes any words or actions that are reasonably likely to elicit an incriminating response. Here, after Ms. Gold was isolated for 2 hours, Deputy Kim re-entered the room with Harper DeRay, Ms. Gold's spouse. And instead of passively listening in on their conversation, Deputy Kim placed his hand on his holstered gun and towered over Ms. Gold, saying, "You better make sure DeRay knows everything. You wouldn't want to jeopardize his position by making him complicit." The 1983 case of State versus Feinhout discusses precisely this issue. There, law enforcement urged a suspect in custody to tell the truth after he had clearly invoked his right to remain silent. The court held that this subsequent advice constituted a continued interrogation under the Fifth Amendment. Now, Your Honor, Deputy Kim took it a step further by taking a seat directly...
So when he said, lay everything out there for your spouse, how is that different than if, let's say, the police in Morrow had said, this is your chance to talk to your spouse about everything?
Well, Your Honor, when we look to the 1987 United States Supreme Court case of Arizona versus Morrow, we can see that the officers never actually spoke to the suspect or the spouse in that case. The officer was silent as he sat in the room recording their conversation. And again, that's not what we have here.
If the officer would have said something in that case, let's say what I just said, this is your chance to talk about your spouse, to talk to your spouse about everything, would that have been a violation?
Yes, Your Honor. And if that were the case in Morrow, then maybe it would be applicable to our own case. But as it stands, Morrow is not applicable to our case, as the officer never inserted himself into the conversation between the suspect and the spouse like Deputy Kim did. May I proceed?
Yes.
Now, Deputy Kim took it a step further by sitting down directly across from Ms. Gold, placing a tape recorder on the table, and telling Ms. Gold to lay it all out. Your Honor, Deputy Kim's actions were not neutral. They were deliberately designed to pressure Ms. Gold into speaking, which brings me to my second point. Ms. Gold was abundantly clear when she told Deputy Kim she did not want to speak, yet Deputy Kim ignored this and continued interrogating her without re-advising her of her rights, violating well-established precedent. For example, in Innis, officers re-Mirandized the suspect before further questioning. Additionally, in Edwards versus Arizona, The officers Mirandized the suspect twice to ensure he was fully aware of his rights during the interrogation. And finally, in Arizona versus Morrow, officers re-Mirandized the suspect after simply transporting him to a police station. Your Honor, the courts in these cases were clear that re-Mirandizing is a basic yet crucial step when it comes to safeguarding a person's Fifth Amendment right. Yet Deputy Kim failed to complete even this simple step. The Fifth Amendment right against self-incrimination is more than just a technicality. It's a safeguard against the overwhelming power of the government. Ms. Gold was abundantly clear when she invoked her right to remain silent, yet Deputy Kim ignored this and compelled an incriminating statement from my client. As such, the defense respectfully requests that this court exclude Ms. Gold's statement and grant the motion to suppress. Thank you.
Thank you. On behalf of the prosecution?
Yes, Your Honor. Deputy Riley Kim didn't violate the defendant's Miranda rights. His actions did not rise to the level of interrogation or any functional equivalent. The defendant's decision to speak with her spouse was informed and voluntary. As Your Honor and opposing counsel have already discussed, the United States Supreme Court, in the seminal case of Miranda versus Arizona, established that police officers must inform in-custody suspects of their Fifth Amendment right to silence prior to any questioning. Deputy Kim fully complied with this requirement. After arresting Logan Gold, he promptly advised the defendant of her Miranda rights. The defendant indicated that she understood, invoking her right to remain silent without an attorney. And Deputy Kim respected this assertion and immediately stopped questioning. Within a couple hours, Harper DeRay arrived at the sheriff's station and demanded to speak with the defendant. Deputy Kim inquired of Gold, explaining that he would need to be present in the room. Yet with that understanding, Gold still desired to speak with DeRay, and that was the defendant's own request.
What about the questions or the comments that were said by the deputy in that room? At that point in time, the defendant had been arrested for kidnapping, held for kidnapping. Her spouse rushed to the station because the defendant was arrested for kidnapping. How could the deputy's words, even if, let's say, they were comments as opposed to questions, how could those words not have been referencing the crime of kidnapping?
Your Honor,
Isn't that an interrogation?
It's absolutely not, Your Honor. Lay everything out for DeRay doesn't elicit a response to the deputy. Instead, it invites the defendant to begin her conversation with Harper DeRay, which is exactly what they were there to do. Nothing about the words "lay it out" required that the defendant confess or discuss case-specific facts. And we have circumstantial evidence to suggest that both spouses were actually aware that they should avoid admissions of guilt. Their conversation began with these discussions of hiring a defense attorney and arranging bail. No one had mentioned innocence or guilt until the defendant surprised everyone in the room with her statement. The evidence shows that even Harper DeRay was surprised by this incriminating statement because it was unexpected. So DeRay immediately ordered the defendant to stop talking and brought her back on topic, assuring that she would arrange legal counsel and bail.
Well, one of the arguments that was made by defense counsel is that there's several cases on point. In Enos, the police Mirandized the defendant a second time. In Edwards, the police Mirandized a second time. Wasn't a second Miranda warning required for any later statement by the defendant to be essentially a knowing and intelligent waiver?
And no, Your Honor, a second Miranda advisement would only be required if this was interrogation at all, but this was a conversation between Logan Gold and Harper DeRay. And to the facts of Rhode Island versus Innis, they are different from our case, but they offer some guidance that's relevant here. In Innis, 2 police officers were driving an armed robbery suspect to the police station, and they were in the same car within clear earshot of each other. And while in that car, the police discussed the danger posed by the suspect's shotgun. They noted that the area had a school for disabled children, and they were worried that a kid may find that shotgun and even harm themselves. Innes heard the conversation, he was moved by it, and he actually responded by directing police to the location of the firearm. And now, here's the important part about Rhode Island versus Innes. Even though the officer's words were likely to affect anyone with a conscience, and even though their words actually elicited an incriminating response, it was still not interrogation under the meaning of the Fifth Amendment because the totality of the circumstances, showed that it was not directed at the defendant.
But I think what counsel's arguing for the defense is that in that case, the deputies were speaking to each other. So they didn't directly speak to the defendant. However, in this case, the deputies' comments were directed at the defendant himself. So doesn't that distinguish the Innes case?
It does not, Your Honor. It's true that the words were said to the defendant, but let's remember that the deputy made comments before their conversation even began. Miranda doesn't prevent police from speaking to in-custody suspects. Their words just can't rise to the level of interrogation set by Innes. And we see these statements, the first one being, lay everything out for DeRay. This wasn't interrogation, it was an invitation to begin speaking.
But here the deputy, in Edwards, there was a second Miranda warning, and something more than just the defendant speaking was required for a knowing and intelligent waiver. Here, the deputy gave no second warning. The defendant just spoke, like you said. At what moment did the defendant make a knowing and intelligent waiver?
Well, the defendant, again, in this case, didn't need a second waiver because when we look at the facts of these cases, the deputy's actions are not the same. In Edwards, a suspect asserted his Fifth Amendment rights, and police stopped questioning at first, but they came back to Mr. Edwards' cell the next day, reread him the Miranda advisement, and began a new round of interrogation. And the High Court held that once a suspect asserts his Fifth Amendment rights, all police questioning must stop. We agree with that, but the facts are not the same as our case. Here, Deputy Kim read Logan Gold her Miranda rights, she invoked them, the deputy immediately stopped. And importantly, the most important distinction from Edwards, Deputy Kim didn't reinitiate contact with the defendant. Instead, it was Logan Gold and Harper DeRay who contacted the police to get this thing going. And this wasn't a ploy by police. It was an accommodation at the defendant's own request.
Go ahead.
Thank you, Your Honor. Once inside the room, Deputy Kim emptied his pockets, placing items including a tape recorder on the table. The presence of that recorder and of the officer in the room was an objective reminder that this was going to be a public conversation. The Supreme Court case of Arizona versus Mauro directly applies here. In Mauro, a police officer was present in the room while an in-custody suspect spoke with his spouse. That officer also placed a tape recorder in plain sight. The High Court affirmed that police may constitutionally record conversations between suspects and their spouses. An officer insisting that he be in the room and that a conversation be recorded is neither interrogation nor coercion.
But in this case, the tape recorder was not recording, correct? So couldn't the defendant just assume perhaps that because the officer did not press record, that that whatever he said wasn't going to be used against him?
Well, Your Honor, even if the defendant had assumed that, I submit that the recorder would actually have the opposite effect of eliciting a response. It would actually have a chilling effect on a reasonable person. As I just mentioned, the presence of the recorder was an objective reminder that this was a public conversation. Any confessions would be preserved as evidence, so any reasonable person should know to mind their words. There's a good reason why police usually disguise the presence of these types of recording devices. It's because a person's more likely to confess if they think police aren't listening, not if they are.
Thank you. Go ahead.
Thank you, Your Honor. Additionally, Deputy Kim's words inside the interview room did not rise to the level of Miranda interrogation. Now, this was Logan Gold's first visitor while in police custody. So, Deputy Kim explained to the couple how these types of exchanges typically work. He explained that this was Gold's opportunity to lay everything out for DeRay. The deputy was relaying an objective fact here. If the couple wanted to have a conversation, this was their opportunity to do so. In Rhode Island versus Innis, again, the Supreme Court emphasized that to constitute an interrogation, police should have known that their words were reasonably likely to elicit an incriminating response. None of Deputy Kim's words meet this standard. So, as we would predict, their conversation began with non-incriminating practical topics. The deputy was completely silent as the couple spoke with each other. The defendant then revealed, quote, "I was trying to make sure the family inn could be passed down for generations." The defendant's words were directed at her spouse. The defendant was not responding to a question, and the defendant was not prompted by the conversation to make an admission. In simplest terms, this was a voluntary statement. Logan Gold's constitutional rights were never violated, and justice demands that these incriminating statements be admitted at trial. Thank you, Your Honor.
Thank you. On behalf of the defendant, rebuttal?
Yes, Your Honor. May I proceed?
Go ahead.
Now, my opposing counsel repeatedly brought up the case of Arizona versus Morrow, which we've already discussed. But I'd like to point out again that Arizona versus Morrow is very different from our case. Now, as the court correctly pointed out, the tape recorder in our case was not on. But in Morrow, the tape recorder was obviously on, as the officer was not speaking to the suspect or the spouse, so why else would he be there but to record their conversation? However, in our case, this is very different. Deputy Kim first gave all these remarks to my client, saying that she could actually make her husband complicit in a crime, Your Honor, and then placing a tape recorder on the table, an off tape recorder, and telling Miss Gold to lay it all out. Your Honor, these actions...
But at that point in time, doesn't your client say that she was unsure of what Deputy Kim wanted her to say? So in response to those comments, she was unsure what Deputy Kim wanted her to say, and then your client's spouse says your client was just upset and rambling, so your client didn't seem to be responding to the deputy's words, which means under Enos, this wasn't the functional equivalent of an interrogation.
Your Honor, I have to respectfully disagree with the court. This was absolutely an interrogation. Now, as the court pointed out, Miss Gold did say that she was unsure what Deputy Kim wanted her to say. However, she did know that Deputy Kim wanted her to say something incriminating, excuse me. My client was just unsure as to what this was, as Deputy Kim had come into the room with her hand on her holstered gun, telling her to tell her husband everything and not make her husband complicit in a crime. Your Honor, the fact that Miss Gold was aware that Deputy Kim wanted her to say something incriminating should show how coercive this setting was. May I proceed?
Yes, go ahead.
Thank you. Now, my opposing counsel also brought up the recorder being off. However, in this case, like we discussed, because Deputy Kim placed it on the table and said, "Lay it all out," this was used as a manipulative tactic to coerce Miss Gold into speaking. Your Honor, here we absolutely had an interrogation. Once again, we need to look to the totality of the circumstances. When Miss Gold has been left alone for 2 hours and Deputy Kim re-enters the room with the one person she would be the most vulnerable around, this is obviously a coercive tactic. Deputy Kim was not required to allow this conversation to happen between Harper DeRay and Logan Gold. And then, when Deputy Kim places his hand on his holstered gun and gives all these remarks to my client about not involving Harper DeRay in a crime, clearly this was an interrogation. Placing a tape recorder on the table and saying, "Lay it all out," clearly Deputy Kim wanted Miss Gold to reveal something incriminating. Your Honor, the Fifth Amendment says that no person can be compelled into testifying against themselves. But Deputy Kim compelled Miss Gold into testifying against herself. As such, the defense respectfully requests that this court exclude Miss Gold's statement. Thank you.
Thank you. on behalf of the prosecution?
Yes, Your Honor. I'd like to begin by correcting the record. Multiple times now, opposing counsel has cited to you subjective beliefs of the defendant. But I must remind this court that Miranda requires that we apply an objective totality of the circumstances test. And this is affirmed by the United States Supreme Court in Stansbury versus California. There, the court explains that we must view the facts from the perspective of a reasonable person, and that any subjective thoughts of the suspect or of police are just not relevant to our analysis. And by saying that she was pressured by the deputy, we just can't use that. So using this test, let's look at the totality of Deputy Kim's actions.
A reasonable person in that same situation would feel the same way?
That's not what my opposing counsel said, though. She said that the defendant felt this way. We're allowed to analyze the totality of the circumstances, but to use these witness statements is not allowed by law. Thank you, Your Honor. Let's use this test to look at the totality of Deputy Kim's actions. First, she read Logan Gold the Miranda advisement, and immediately, once she invoked those rights, he stopped questioning. Later, when Harper DeRay showed up at the sheriff's station, they could have walked her into the room, surprised Gold, and even recorded any emotional admissions caused by the unexpected visit, but they didn't.
I'm concerned with the potentially coercive nature that was cited to by counsel of the tape recorder. So isn't this a pure Miranda violation by presenting that non-recording tape recorder? So putting the tape recorder down, it's not recording, as if saying, you know, your words, and going back to what I asked you before, is your words won't be recorded or used against you. So at that moment, hadn't the deputy improperly misrepresented the defendant's Miranda rights to the defendant and essentially needed to read the Miranda rights again? Because putting the tape recorder down, not recording, seems to be it's not going to be used against you.
Your Honor, we know that on or off, the tape recorder is legal under the binding case authority of Arizona versus Mauro. In that case, the tape recorder was on the table, it was actually on, and despite that, the court held that it was neither objectively interrogation nor coercion. Even if the defendant did subjectively think, though we're not supposed to use that in this case, that it was on, it wouldn't matter because binding case authority supports it. And I'd like to expand on that if I may. The defense's claim that that tape recorder was coercive ignores the totality of the facts. When she entered the room, she emptied her pockets, placing her personal belongings on the table. Among these items were keys, sunglasses, and a small tape recorder. The deputy literally reached deep in her pockets and emptied out all of their contents. That's hardly a power move. In fact, it's the opposite. Any reasonable person would understand that the deputy, by taking out all of these items, was just emptying his own pockets.
Thank you. Go ahead.
Thank you, Your Honor. They could have walked DeRay into the room without asking Gold, but that's not what happened. Instead, Deputy Kim asked Gold whether she wanted to speak with DeRay. Deputy Kim gave Gold agency over the decision. He empowered the defendant to make the call herself. And finally, police were completely transparent in explaining that there would need to be an officer present in the room, which allowed Gold to make an informed decision. That is the opposite of coercion. Logan Gold's statements were lawfully obtained. They are directly relevant to the issue of motive and should be admitted at trial. Thank you, Your Honor.
Thank you. Thank you to you both. At this time, based upon the argument that has been presented, I am going to deny the defendant's motion, finding that it was not an interrogation based upon the totality of the circumstances, and also that there was no direct connection or causation between the comments that were made by Deputy Kim and the statements that were then made by the defendant. So at this time, the motion is denied.
Thank you, Your Honor. At this time, may my co-counsel take their place at counsel table?
Yes.
Thank you.
Permission from the people as well?
Yes.
Thank you.
Your Honor, before we proceed with opening statements, the defense has some housekeeping matters in which we would like to address. Firstly, pursuant to Rule 3.1b, the fact situation found on pages 9 through 12 of the mock trial case materials is a set of indisputable facts which all witnesses may refer to. Secondly, pursuant to Rule 3.4a, witnesses will remain in the courtroom for the entire trial. Next, pursuant to Stipulation 5, both the prosecution and the defense's experts are qualified experts who can testify to each other's statements, the statements of other witnesses, the exhibits, and the fact situation. And finally, Your Honor, the defense would like to ask permission to move freely about the courtroom during opening statements and closing arguments, with the exception of the well.
Yes.
Thank you, Your Honor. And with that, we are ready to proceed with opening statements.
Okay, thank you.
Your Honor, the people also have some brief preliminary matters that we would like to address.
Go ahead.
First, pursuant to Rule 3.1, the stipulations have already been read into the record and their reading has been waived. Next, pursuant to Rule 3.2, the people have brought 6 exhibits, which have been pre-marked as People's A through F for identification, and they've been shown to defense counsel. Next, Your Honor, pursuant to Rule 3.4, as defense counsel mentioned, witnesses will remain in the courtroom, but pursuant to Rule 3.4b, witnesses may not testify or respond to another witness's testimony unless otherwise stated in their stipulations. So they will be considered constructively excluded from trial. And with that, the people are ready to begin with opening statements.
Okay, thank you. And then on behalf of defendant, do you intend to do an opening statement or reserve?
We do intend to do our opening statement now, Your Honor.
Okay, thank you. So on behalf of the people, go ahead.
Thank you.
Ready. You can proceed.
Logan Gold was used to getting what she wanted. She inherited the one and only hotel in the resort community of Emerald Bend. But then came Airbnb. The vacation rental business threatened to bankrupt the defendant's beloved family hotel. The defendant, she was not going to let that happen. She had a plan. Persuade her spouse to run for the open city council seat that would hold the deciding vote to restrict those vacation rentals. But there was a problem. Taylor Alexander was also running, and the race was close. It was all coming down to one final debate, 3 days before the election. You will learn the defendant was panicking because she knew her spouse, Harper, was not a strong public speaker. So the defendant hatched a new plan. On the morning of the debate, the defendant waited outside Mr. Alexander's home, knowing he jogged alone every morning. The moment that Mr. Alexander stepped outside, the defendant grabbed him, put a pillowcase over his head, bound his arms, and drove him across town in the back of her truck. She then held him for hours, forcing Mr. Alexander to drink a liquid that drugged him into unconsciousness. Detective Riley Kim, who responded to the scene, will explain that the pillowcase used to kidnap Mr. Alexander was from the defendant's own hotel. And the captor repeatedly used the defendant's signature catchphrase. And you will learn the defendant intentionally planted this evidence so that she could claim, "I've been framed." But the defendant made mistakes. Dr. Ray Forrest will explain that distinctive tire tracks found outside the property where Mr. Alexander was held captive matched the defendant's vehicle. And the police caught the defendant clearing her car with oxalic acid before law enforcement could search it for evidence. Your Honor, the defendant resorted to violence and manipulation to protect her beloved family in. We are confident, after you hear all the evidence, you will tell the defendant, her deception ends here. We are confident you will find Logan Gold guilty of kidnapping. Thank you.
Thank you.
Your Honor, before I proceed with my opening statement, I ask that the deputy place exhibits A and B on the easels.
Yes, the deputy can do that, please. Okay, you can proceed.
Thank you, Your Honor. Desperation breeds contempt. Taylor Alexander's desperation was the perfect breeding ground for his contempt of Logan Gold and Harper DeRay. Your Honor, the evidence will show that Taylor saw DeRay's campaign to ban short-term rentals in Emerald Bend as a direct attack on Taylor's only means of income. You'll see that after losing his job, Taylor had been eager to ride the wave of short-term rentals in Emerald Bend, purchasing 2 homes near Lake Ambrosia to rent out. You'll hear that at first Taylor tried to play by the rules and ran for city council to oppose Harper. But as Taylor's desperation grew, so did his needs for desperate measures. Your Honor, by the end of tonight's trial, you will not only be convinced of Miss Gold's innocence, but that Taylor Alexander orchestrated and acted out his own kidnapping. You see, Taylor will tell you the most incredible story, Your Honor, but you'll find that it's just that, a story. He stepped outside of his house when someone came up behind him with a pillowcase and covered his head. Then they grabbed both of his wrists and forced him behind his back. Next, in an impossible maneuver without losing control of his hands, they managed to tie both of his hands together. Then they managed to overpower Taylor and force him into the trunk of a car. Taylor will tell you he was in the trunk for about an hour while the car drove. And when the car stopped, he was forced to be taken out of the trunk, and then he was dragged down a muddy slope, getting mud on his sweatpants and t-shirt hood, resulting in no injuries. Your Honor, Taylor will tell you that he was shoved into a chair, and that his hands were untied and then retied behind the chair, both of his legs also being bound to the chair. Now, Your Honor, Taylor will tell you that his kidnapper forced a straw from the hole in the pillowcase and in between his lips, and said in a distorted voice, "Drink this or there'll be consequences." So Taylor just drank whatever unknown substance was being given to him, twice, causing him to lose consciousness and wake up later in the afternoon. Your Honor, Taylor will tell you that at this point, he realized he was actually on his own property on Lakeside Drive. And as luck would have it, he just so happened to have the keys to this property on him the entire time. He then used these keys to go inside and call the police. Now, Your Honor, you will hear about tire track evidence from the people's expert, Dr. Forrest. But the defense forensic expert, Dr. Palmer, will tell you that Dr. Forrest's measurements are inaccurate, and his conclusions are unsupported. Now, Your Honor, you will hear from Deputy Riley Kim that the pillowcase is from the Gold Standard Inn, an inn that Miss Gold owns. And written on the pillowcase were the words, "DeRay for Emerald Bend," which you'll find to be a clear attempt to cast suspicion onto Miss Gold. And the pillowcase, pursuant to Stipulation 18, was booked into evidence but has mysteriously gone missing and has not been made available for forensic evaluation. Now, Your Honor, you will hear from Miss Gold, who will categorically deny committing a kidnapping and will explain where she was throughout the morning of November 11th, which will be corroborated by the testimonies of both C.J. Crossley and the people's own witness, Deputy Riley Kim. Finally, Your Honor, you will hear from Harper DeRay, Miss Gold's husband, who will tell you that, among other things, Miss Gold is kind, caring, and supportive, all character traits inconsistent with a violent kidnapping. Your Honor, desperation breeds contempt. And by the end of tonight's trial, you will be able to clearly see the desperation born from Mr. Alexander's contempt of Miss Gold. And it is then, Your Honor, that my co-counsel, Miss Singh, will be asking you to find Logan Gold not guilty. Thank you, Your Honor.
Thank you. On behalf of the prosecution, should I call in first witness?
Yes, Your Honor. The people call Ali Sandoval.
Okay.
Ali Sandoval, please follow me.
Your Honor, may I give time remaining for closing arguments?
Yes, go ahead.
prosecution has 6 minutes and 6 seconds left for closing arguments, while the defense has 4 minutes and 54 seconds remaining for closing.
Thank you.
Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. And state your full name, spelling the last for the record.
Ali Sandoval, Sandoval.
Go ahead, whenever you're ready.
Good evening, Miss Sandoval.
Good evening.
How are you currently employed?
I am a staff writer on the political beat at the Emerald Bend Daily Reporter.
I'd like you to give some context as to the political landscape in Emerald Bend in the fall of 2023. Did you cover the city council race?
Yes. Once the race became so contentious, of course my editor assigned me to cover it full time. I called my first article "To Airbnb or Not to Airbnb."
Why did you title it that?
The two candidates were arguing over whether we would restrict vacation rentals or keep expanding. Whoever won the race would be the deciding vote on the city council.
So how did you go about covering this race?
Like any experienced reporter, I needed to gather all the facts. So I went to all the campaign events, and I interviewed both candidates Harper DeRay and Taylor Alexander and their campaign advisors.
Did this include Logan Gold?
Yes, I interviewed Logan several times.
And who is Logan Gold?
Logan Gold is Harper DeRay's campaign advisor and wife.
And do you see Logan Gold in the courtroom today?
Yes, she's seated at the end of the long table wearing a blue blazer.
Your Honor, may the record reflect that Miss Sandoval has identified the defendant as Logan Gold?
Yes.
Now, did you know of the defendant prior to your work on this election?
Logan used to date my brother Sam years ago. Emerald Bend is a really small town. But I never actually met Logan while they were dating.
So did this relationship impact your reporting?
Of course not. The relationship ended badly and Sam left town and moved on. And while I felt bad for my brother, I have nothing against Logan.
Objection, Your Honor. Relevant. May I be heard?
Go ahead.
Your Honor, this is relevant as it shows Miss Sandoval's lack of bias, as she holds nothing against the defendant for the relationship that happened between her brother and the defendant.
Your Honor, may I be heard?
Yes, go ahead.
Your Honor, Miss Sandoval's younger sibling's relationship with Miss Gold over years ago has no problems to any of the cases issued today. It simply serves to paint Miss Gold in a bad light.
Your Honor, may I respond?
No, I've heard enough, so I'm going to overrule the objection and you can continue.
Thank you. Now, were there any campaign events scheduled for November 11th?
Yes, the Daily Reporter was hosting the final candidate debate, and I had my press pass, so I had VIP access.
And what time was this debate supposed to start?
Noon, but it ended up being canceled.
Why is that?
Taylor Alexander never showed up.
Was Harper DeRay there?
Yes, Harper was ready to go.
And what about the defendant?
Logan showed up late, around 12:30.
Was it unusual for the defendant to arrive late to campaign events?
Yes, I got to know Logan's habits pretty well, and she was painfully on time, even cutting off my interviews with the candidate if I went a minute over.
So what happened when the defendant finally arrived?
It was strange. It definitely had my reporter senses tingling. Harper went up to Logan and asked what was going on, and Logan said, quote, "It's all been taken care of," end quote.
And how did the defendant appear?
Look, this never made print, but she was out of breath and frazzled.
Thank you. Nothing further, Your Honor.
Thank you.
Cross, Your Honor.
Yes, go ahead.
May I proceed?
Go ahead.
Good evening, Miss Sandoval.
Good evening.
During your coverage of the city council race, it became apparent to you that the main issue was vacation rentals, correct?
Yes, it was very contentious between the town.
In fact, you noted that the emotions were extremely high, correct?
They were.
And just so we understand, the DeRay campaign platform was to ban short-term rentals, correct?
That's correct.
And the Alexander campaign platform was to increase short-term rentals, correct?
Yes, ma'am.
And whether Taylor Alexander and Mr. DeRay won, they would be the deciding vote that was split on this issue, correct?
Like I said earlier to the other attorney, ma'am, yes.
Now, during your coverage, you noticed that there was animosity between Taylor Alexander and Miss Gold, correct?
There was, yes.
And let's talk about Miss Gold for a minute. You noted that she had a catchphrase, correct? She often said, everything comes back around. Is that
Yes, she'd say it in conversations and in interviews as well.
You heard her say this repeatedly throughout the race, right?
Yes.
And in a variety of conversations.
Like I said earlier, yes.
So it's reasonable to believe that other people have heard Miss Gold use this phrase. Would you agree?
Yes.
Now, Ms. Sandoval, on direct, you testified that Miss Gold arrived late to the debate on November 11th. Is that right?
Yes, she showed up about 30 minutes late.
And you heard her tell her husband it's all been taken care of, right?
Yes, but I have no context to what their conversation was about.
Thank you, Miss Sandoval. Your Honor, nothing further.
Thank you.
Redirect, Your Honor.
Go ahead.
Now, Miss Sandoval, in the animosity that you noticed, who generally had the animosity?
Logan would start most of the arguments.
Thank you. Nothing further, Your Honor. May this witness be excused?
Yes.
And at this time, the people call Taylor Alexander.
Taylor Alexander, please follow me.
Your Honor, time remaining for cross and direct. The prosecution has 11 minutes and 1 second remaining for direct, while the defense has 8 minutes and 29 seconds remaining for cross.
Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. And state your full name, spelling the last for the record.
Taylor Alexander, Alexander.
And, Your Honor, before I proceed, I'd like to remind the court of Stipulation 10, which provides that although it may not look like it, the defendant and Mr. Alexander are the same height and weight.
Thank you. Go ahead.
Thank you. Good evening, Mr. Alexander.
Good evening.
How are you currently employed?
Well, last fall I ran for Emerald Bend City Council, fall of 2023, but as of now I own a couple of vacation rentals.
Why did you run for city council?
Really one issue. Emerald Bend's economy was struggling. I felt strongly that increased vacation rentals would help it. I own a couple of rentals myself, so I've experienced firsthand how beneficial they can be.
Now, were there any campaign events scheduled for November 11th?
Yes, that was scheduled to be the final debate between me and Harper DeRay.
So what time did you leave your house that morning?
5:30.
Why 5:30?
Well, I keep a strict morning routine. I go for a run every day at 5:30. It helps keep my mind clear.
Have you ever discussed this routine with anyone?
I'm quite proud of it, so I talk about it frequently.
Now, do you know Logan Gold?
Yes, Logan was my opponent's campaign manager.
Did you ever tell Logan Gold that you go for a run every morning at 5:30?
I specifically remember telling her.
So what happened when you stepped out for your usual morning run on November 11th?
As soon as I stepped out my front door, someone came up behind me. They caught me completely by surprise. They threw a cloth over my head and my hands were tied behind my back.
What happened next?
Well, by the time I figured out what was going on, it was too late. And that's when they threw me into the trunk of a car.
And after you were forced into this car, what happened?
Well, we drove for a while, and then we stopped, and then I was pulled out of the car and forced down a hill. It was slippery and muddy, and I kept falling.
What did your attacker do next?
I was thrown onto a metal chair, and my wrists and ankles were tied, so I couldn't move.
As you were tied to this chair, how did you feel?
Panicked. Scared. I begged for them to let me go, but they just said I'd brought this on myself.
Did you recognize the voice of your attacker?
I wish I could, but no. It was gravelly and it seemed like they were changing it.
Did your attacker do anything else to you?
They poked a hole in the cloth that was over my head, forced a straw into my mouth, and told me to drink, or else there'd be consequences.
Can you describe this liquid for us?
It was thick and sweet. It tasted a lot like cough syrup, and it felt a lot like cough syrup. I passed out within a half hour.
What do you remember next?
I remember being shaken awake, and then forced to drink more of that liquid. And then I passed out again.
As you were being forced to drink more of this liquid, did your attackers say anything else to you?
Yes. They said, everything comes back around.
Objection, hearsay. May I be heard?
Yes, go ahead.
Your Honor, we are not offering this for the truth of the matter. We are not offering it to show that everything actually comes back around or to prove that karma is actually real. Instead, Your Honor, as an offer of proof, I expect this witness to testify that the phrase, everything comes back around, was the defendant's catchphrase. Therefore, this is being offered as circumstantial evidence of the defendant's identity.
Your Honor, may I be heard?
Go ahead.
Your Honor, if the people are seeking to not use the statement, everything comes back around for its truth, but to link Miss Gold to the crime because Miss Gold has been said to say the phrase, everything comes back around, is tenuous at best, speculative, and highly prejudicial. And so I object more prejudicial than probative. Your Honor, at some point, everyone in this court has said the phrase, everything comes back around. The statement is hardly unique to Miss Gold.
Your Honor, may I respond to that?
Go ahead.
For this to be more prejudicial than probative, it requires a clear lopsidedness, such that the prejudice is extreme and the probative value is minimal. However, that is not the case here. The probative value of this evidence far outweighs the complete lack of prejudice. Throughout this kidnapping, the assailant used the phrase, everything comes back around, something only the defendant was known for using. Therefore, this is incredibly relevant as it places the defendant at the scene of the crime.
Your Honor, may I be heard?
Yes, last time.
Your Honor, the people are trying to link Miss Gold to the crime because she uses the phrase, everything comes back around. I believe it to be more prejudicial than probative because, Your Honor, everybody says that phrase and is not a catchphrase. A catchphrase would be, hey, how you doing, by Joey from Friends, or what you talking about, Willis, from Arnold from Different Strokes. This is clearly not a catchphrase.
At this time, I'm going to overrule the objection. So thank you. Go ahead.
Now that phrase, everything comes back around, is that significant to you?
Yes. Logan Gold says it in public all the time. It's basically her catchphrase.
And when you came to the second time, what happened?
Well, I realized that my hands were untied. So I took the cloth off my head. It was a pillowcase, and I noticed that I was in the shed of my own rental property.
And when you realized you were on your own property, what did you do?
Thankfully, I had my keys in my pocket from that morning, so I went up to the house and used the landline to call 911.
Mr. Alexander, what happened with the debate?
I missed it. The election was 3 days later. I lost.
Thank you. Nothing further, Your Honor.
On behalf of the defendant, go ahead.
Yes, Your Honor.
May I proceed?
Yes, go ahead.
Good evening, Mr. Alexander.
Good evening.
You own 2 properties that you rent out as short-term rentals, correct?
I do own 2 rental properties,
And in
yes.
fact, the rent from those 2 properties was your only source of income, correct?
At the time, that was my only source of income, yes.
And at the time of the election, the city council was split evenly on the issue of short-term rentals, is that right?
Yes, that's true, as well as the town. Pretty even.
And Mr. DeRay, your opponent in the election, spoke out fervently against vacation rentals like yours, right?
I wasn't concerned about my personal income.
Yes.
Not my rentals, so no. They spoke out against rentals, but my rentals
All right,
weren't at
moving
risk.
on, Mr. Alexander. If Mr. DeRay won the election, oh, pardon me, during the election you became aware of the case of West Betha, correct?
I believe Mr. Costley, a podcaster, said something about West Betha, so I listened to a little clip.
Exactly, and that was the case where Mr. Betha faked his own kidnapping. Is that right?
Yes, and I believe that he should go to jail for
Thank
years.
you, Mr. Alexander. Now moving on, I just have to ask, you're a pretty good actor, right?
No.
Isn't it true that you were awarded the Best Actor Award from your drama club while in college?
I participated in the drama club as a hobby,
Did
but
you
there
win
wasn't.
this award, Mr. Alexander?
It was just a club, so there wasn't much competition. So I did win an award.
Thank
I'm not
you.
sure how.
Moving on the morning of November 11th, you say that someone came up behind you at your home and put a pillowcase over your head. Is that right?
Yes, they caught me completely by surprise, and then
Right, and they
put a
grabbed
cloth
both
over my
of your
head.
wrists and tied them behind your back. Do I have that right?
Yes, all of a sudden my hands were behind my back and
And
bound.
forced you into the trunk of a car, correct?
Yes,
And once the car stopped, you were dragged on a muddy hill. Is that right?
I was. I kept falling.
And at some point, your hands were untied and then retied behind a chair. Is that right?
I can't recall exactly, but my hands were tied behind the chair.
And both your legs were tied to the chair as well.
Yes, they were.
And then at some point, a straw was put in your mouth. And you just drank whatever unknown substance this was.
Well, the kidnapper told me that if I didn't drink, there would be consequences. So I was left with no choice.
Now, when you woke up, you realized that you were at one of your own vacation rentals, correct?
Yes, I was.
And you realized that you had the keys to this particular rental home on you the entire time. Is that right?
Well, I keep all my keys on a ring, and I
Is that
put.
a yes, Mr. Alexander?
I had my keys from all my properties, and they were in my pocket from that morning.
Thank you, Mr. Alexander. Your Honor, nothing further.
Thank you. On behalf of the full?
Yes, Your Honor. Mr. Alexander, did you stage your own kidnapping?
Absolutely not. I would never do anything like that.
Mr. Alexander, are you acting right now?
No, not at all.
Thank you. Nothing further, Your Honor. May this witness be excused?
Yes, you can sit down.
Thank you.
And you can call your next witness.
Yes, Your Honor. The people call Riley Kim.
Deputy Riley Kim. Please follow me.
Your Honor, time remaining for directing the cross.
Yes, go ahead.
Please stand.
The prosecution has 6 minutes and 30 seconds remaining for direct, while the defense has 5 minutes and 29 seconds remaining for cross.
Thank you.
Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. And state your full name, spelling the last for the record.
My name is Riley Kim, K-I-M.
Go ahead whenever you're ready.
Thank you, Your Honor. Good evening, Deputy.
Good evening, counsel.
What is your background in law enforcement?
I've been a law enforcement officer for over 20 years, and currently I serve as the deputy sheriff with the Emerald Bend Sheriff's Department.
On November 11th of 2023, did you respond to a call at 1335 Lakeside Drive?
I did. I responded to a call of a possible kidnapping at that location.
And what happened when you arrived at the scene?
When I arrived, I saw a man, who I later identified as Taylor Alexander, standing on the porch of the house.
And how did Mr. Alexander appear?
His clothes were covered in mud, and he looked very distressed. And I also noticed that he had red inflamed marks on both of his wrists. They appeared to be ligature marks.
Was Mr. Alexander holding anything?
He was. He was holding a pillowcase with the Gold Standard Inn embroidery on it, and it had the words DeRay for Emerald Bend written on it in black Sharpie.
So what was the first step in your investigation?
Well, first, I photographed a set of tire tracks in the dirt driveway, and second, I collected 2 pieces of rope near a metal chair in the shed that Mr. Alexander reported being bound.
What did you do with the photos and evidence you collected?
I submitted them to the forensic investigator, Dr. Ray Forrest. However, I should inform the court that sometime after I booked the pillowcase into evidence at the station, it went missing from the property room.
So what'd you do next?
Next, I interviewed Mr. Alexander's political opponent, Mr. DeRay, and several members of his campaign staff, including Logan Gold.
Do you see Logan Gold in the courtroom today?
I do. She is seated to my right at the end of defense counsel table, wearing a blue blazer.
Your Honor, for the record, indicating the defendant.
Yes.
After your interview of the defendant, did you search any of her personal belongings?
I did. I searched the defendant's car and took photos of her car's tires.
And did you investigate the defendant's whereabouts on the day of the kidnapping?
I did try through either her cell phone or the GPS in her car.
What did you find?
Well, the defendant told me that she had left her phone at home that morning, and her vehicle wasn't equipped with any GPS, so it was impossible to electronically track her whereabouts the entire morning.
Did you eventually arrest the defendant for kidnapping?
I did, on December 4th, 2023.
Objection, relevance, Your Honor, may be heard.
Go ahead.
Your Honor, there are two reasons why the people may be seeking to introduce evidence of Miss Gold's arrest. The first is for identification purposes of Miss Gold in court here today. However, Your Honor, as you just heard, the deputy was able to identify Miss Gold without making reference to any arrest. And the second reason why the people may be seeking to introduce evidence of Miss Gold's arrest is to prejudice this court against Miss Gold by introducing evidence that Deputy Kim believed that Miss Gold was guilty. Your Honor, whether or not the deputy believed that Miss Gold was guilty does not make Miss Gold's guilt more or less probable. I'd like to remind the court that evidence that Miss Gold was arrested, charged with a crime, and brought to trial is not evidence of anything. Therefore, it is simply irrelevant, Your Honor.
May I respond, Your Honor?
Go ahead.
Your Honor, this question is foundational. My later questioning will reveal that the defendant, while in police custody, confessed to her spouse that she was just trying to make sure the family name could be passed down for generations. Your Honor, this is an admission of guilt and is extremely relevant at trial today.
Well, I am going to overrule the objection. I think this is a court trial, and the court will consider your argument as well and understands it.
Thank you, Your Honor.
So, go ahead.
I did arrest the defendant on December 4th, 2023.
And while in police custody, did the defendant say anything suspicious?
Yes, at one point when speaking with her husband Harper, she said, and I quote, "I was trying to make sure the family inn could be passed down for generations."
And what happened next?
Well, Harper DeRay immediately told the defendant to stop talking.
Thank you, Deputy. Your Honor, nothing further.
Your Honor, before I proceed with cross-examination, I ask that the deputy place Exhibit D on the easel.
Yes, Deputy, if you could place Exhibit D, please.
May I proceed?
Yes, go ahead.
Now, Deputy, when you arrived on scene, you saw Mr. Alexander standing outside holding a pillowcase, correct?
Good evening, and yes, that is what I found.
And you indicate in your report that both of his sweatpants and t-shirt were muddy, right?
Yes, his entire outfit was covered in mud.
However, Deputy, you don't indicate in your report whether the pillowcase had any mud on it, correct?
Objection, Your Honor, unfair extrapolation.
Your
May I
Honor,
be
may
heard?
you heard?
Okay. Go ahead. You finish what you're saying first.
Yes, Your Honor. Nowhere in this witness's statement or the fact or any of our case materials does it indicate whether the pillowcase was muddy. That is an unfair extrapolation used to help the defense's case.
Your Honor, may I be heard?
Yes.
Your Honor, I am not asking the deputy to testify.
I want to ask you if there's any line you can point to that speaks of
Right.
anything on the pillowcase.
I'm not asking the deputy to testify that the pillowcase was muddy. I'm asking whether or not they indicate in the report whether the pillowcase was muddy. However, if I were asking the deputy something that is outside of their witness statement, pursuant to Rule 3.5E, if a witness is asked a question that is not contained in their witness statement, they must answer in a way that is consistent with their witness statement. Here, a consistent answer for Deputy Kim would be for him to testify that, no, he did not indicate this in the report, because if we look in his report, we notice that they do not make any indication of the pillowcase being muddy, Your Honor.
May I be heard, Your Honor? Those two questions are functionally the same. This opposing counsel is asking this witness to make up a fact that is nowhere in our case materials. That is the definition of an unfair extrapolation which is not allowed in trial today.
Your Honor may be heard.
No, I don't need to hear from you any further. I am going to rule on the objection and indicate that I'm going to sustain the objection.
Move to strike.
Indicating that it is unfair extrapolation. Unless you were able to point me to something in the record that specifically said that. If it hasn't been mentioned in the record, then I assume it wasn't mentioned because it wasn't intended to be discussed or asked about during questioning. So.
Your Honor, move to strike any answer given if there was, or opposing counsel withdraw their question.
I don't recall any answer given, so I will not consider the question, and the question will be stricken.
Thank you.
Go ahead.
Thank you. Deputy, you booked the pillowcase into evidence, but it's gone missing, correct?
Unfortunately, yes, it has.
Now, Deputy, I'd like to direct your attention to Exhibit D. These are the 2 pieces of rope you collected from the scene, correct?
Yes, in the shed that he reported being bound, yes.
Your Honor, may I approach?
Go ahead.
Deputy, you collected these 2 pieces of rope because while you interviewed Mr. Alexander, he indicated that both his legs and hands had been bound to a chair, correct?
That's right.
Now, if we take a closer look at these ropes, we notice that there aren't any knots in them, correct?
That is true. It is a
In
straight rope.
fact, the ends are frayed, right?
As you can see, that is true.
And you only found these 2 pieces, correct?
That is all that I found in the shed.
Thank you, Deputy. Now I'd like to direct your attention to Exhibit A. This is a map of the north side of Lake Ambrosia, correct?
Yes, and I created this diagram.
Thank you, Deputy. And in your interview of Ms. Gold, she told you that the morning of the debate, she had been out passing out flyers near C.J. Cossey's home, correct?
Objection, Your Honor. Hearsay as to the defendant's statements to the officer.
Your Honor may be heard.
Go ahead.
Your Honor, hearsay is an out-of-court statement offered for the truth of the matter asserted. Here, Ms. Gold's statement to the deputy is not being offered for the truth, but to explain the deputy's subsequent conduct. As an offer of proof, I expect the deputy to testify to my next question, that after hearing this from Ms. Gold, the deputy went out and searched the houses near C.J. Cossey's home and was able to confirm that 12 houses did have DeRay flyers on their porches. Additionally, the people have already stipulated to this fact in stipulation 19.
May I be heard, Your Honor? As long as opposing counsel's questioning isn't calling for the truth of the matter asserted that Logan Gold was indeed passing out flyers, then I submit my objection, as long as it's being used for that limited purpose.
Okay. I will overrule the objection then and use the response for that limited purpose.
Thank you.
Your Honor. Now, Deputy, Ms. Gold did tell you this, correct?
Yes, the defendant said that her alibi was that she was passing out flyers near
Right,
C.J.
Deputy.
Cossey's
And
house.
during your investigation, you were able to confirm that 12 houses around C.J. Cossey's home did have DeRay flyers on their porches, correct?
That is true.
Thank you, Deputy. Your Honor, no further questions.
On behalf of the prosecution?
Redirect, Your Honor?
Yes, go ahead.
Thank you. Deputy, did you follow up with the defendant's supposed alibi?
Of course, as a part of my thorough investigation. However, I confirmed that the defendant only spoke with C.J. Cossey for 5 to 10 minutes, and there were a dozen flyers found on the homes around C.J. Cossey's. However, none of the residents could confirm seeing the defendant except for C.J. Cossey.
Thank you, Deputy. Your Honor, nothing further. May this witness be excused?
Yes, you can step down. Thank you.
Thank you, Your Honor.
And you can call your next witness.
Yes, Your Honor, but before you do, the people request a time check on behalf of both sides.
Okay, time check, please.
The prosecution has 3 minutes and 23 seconds remaining for direct, while the defense has 3 minutes and 57 seconds remaining for cross.
And Your Honor, the people call Ray Forrest.
Dr. Ray Forrest, please follow me. Please stand here. Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. And state your full name, spelling the last for the record.
Ray Forrest, Forrest.
And Your Honor, before I begin with direct examination, may I have a moment to arrange the exhibits?
Yes, go ahead.
Thank you. Thank you. Good evening, Doctor.
Good evening.
What do you do for a living?
I am currently Rowan County's chief forensic investigator.
And how are you involved in today's case?
I conducted a toxicology screening on Taylor Alexander. I also examined some rope as well as some tire tracks.
What was the first thing that you did?
First, I drew a sample of Mr. Alexander's blood and conducted a screening on it.
And what'd you find?
There were 2 drugs I observed in Mr. Alexander's bloodstream. Dextromethorphan I found only in trace amounts. However, there was a large quantity of doxylamine detected.
How much doxylamine?
The concentration I observed was 160 nanograms per milliliter.
And doctor, what exactly is doxylamine?
Doxylamine is a sleep aid, commonly used to treat insomnia. You've actually probably had doxylamine before, considering that it is a common ingredient in cough syrups.
If someone had been given a normal dose of cough syrup, would you expect to see a concentration that high?
No. I would expect to see maybe 120 nanograms per milliliter, and again, that is the peak concentration I would expect if one was given the recommended dosage.
2 minutes.
And if someone had been given that much doxylamine, how long could they possibly be unconscious for?
Depending on the person, as long as 6 hours.
Now, doctor, I want to discuss some of the other evidence that you examined. Permission for this witness to approach the exhibits.
Yes, go ahead, you can stand.
Directing your attention to Exhibit D. Do you recognize this?
Yes, this is the rope, or rather, 2 ropes that Deputy Kim asked me to examine.
And what were you looking for when you were examining this rope?
I compared the measurements of the rope to the ligature marks found on Mr. Alexander's wrists.
Now, you also mentioned tire tracks.
Yes, I examined the tire tracks found at the scene of the crime and compared them to the tires of Logan Gold's vehicle.
And directing your attention to Exhibit B, do you recognize this?
Yes, this top photo is of Miss Gold's passenger side tire. You can see here there's a pebble lodged in between the treads. Now, these second and third photos, they are the impressions left in dirt at the scene.
And what is your overall opinion about the tire tracks?
I found that Miss Gold's tires were consistent with the impressions that I found in both pattern and depth. In addition, this pebble lodged in the tire treads, it's consistent with this impression that I circled here. I do believe it was Miss Gould's tires that left these impressions at the scene of the crime.
And going back to Exhibit D for a second, did you find the rope to be a match?
Yes, I did find the rope to be a match.
Thank you, doctor. You may resume your seat. Your Honor, nothing further.
On behalf of the defendant, go ahead.
Cross, Your Honor. May I proceed?
Go ahead, yes.
Dr. Forrest, you say that in your professional opinion, Alexander was given 1.5 times the therapeutic dose of doxylamine initially, correct?
Good evening, and yes, that is the amount I believe the initial amount was.
Right, and with that amount of doxylamine, Alexander would have been unconscious for the better part of 6 hours, isn't that right?
That is correct. It's likely he would only rouse when shaken.
And exactly, he was shaken awake, but we do not know when this was, right?
No, Mr. Alexander had no way of recalling.
Now, doctor, you are aware that Mr. Alexander alleges that he was kidnapped at 5:30 in the morning, isn't that right?
I am aware of that.
You're also aware that he alleges that he was driven in the trunk of a car for approximately an hour, correct?
Mr. Alexander did recall that.
And he sat in a chair for, quote, some amount of time before taking his initial dose?
Again, those are his words.
So, doctor, if Mr. Alexander's timing is accurate, that would mean Mr. Alexander received his first dose at about 7 a.m. Do you follow?
If all of those were perfectly accurate, it's possible that the initial dose was
Right,
around
and
that.
if his captor shook Alexander awake 6 hours later, that would mean he woke up at 1 p.m. Do you follow?
Objection, Your Honor. Unfair extrapolation. In this witness's statements, there are not times mentioned as per Taylor Alexander's dosages given, or being shaken awake at all.
Your Honor, may I be heard?
Yes.
Your Honor, I am asking Dr. Force to follow up and
a hypothetical which would require him to testify when Mr. Alexander was given his, when he was woken up according to this hypothetical, which I'm allowed to ask expert witnesses.
Well, is there any time, though, that you're basing the hypothetical on that's in the record that you could point me to?
Yes, Your Honor, I'm basing it off of Mr. Alexander's allegations and his timeline.
Your Honor, there is no mention of actual times in Mr. Alexander's statement, which the doctor did review. Because there is no time mentioned, I believe this is an unfair extrapolation.
Well, in order for me to allow the questioning, I would want you to point me to some time in the record, line and page, if you're able to do that.
Doctor, excuse me, Your Honor, I'm asking the doctor hypothetical, so there are technically no specific times, but I'm just asking him to follow along with the math, simply.
Well, if there's no times in the record, and then hypothetically you're asking him times, but there has to be at least one time that the hypothetical is pertaining to. Otherwise, it's just hypothetical times, and so if there's one time that
Your Honor,
surround the hypothetical around.
on page 30, excuse me, Your Honor. On page 32, line 2, Dr. Forrest, or Mr. Alexander says, that morning at 5:30 a.m., I put my keys in my pocket and stepped out for my usual morning run.
Your Honor, I do not. This opposing counsel's line of questioning focused on 1 p.m. when the captor was allegedly shaken awake. That fact is nowhere in the statement. We have evidence from Taylor Alexander that was elicited that he went on a run at 5:30 every morning. But that doesn't actually have to do with the kidnapping in this case or the sequence of events that have to do with the amount of doxylamine given to Taylor Alexander. And that is why it's an unfair extrapolation.
Your Honor, may be heard. Well, just let him finish first, and then I'll give you the chance to be heard. So go ahead.
Your Honor, I asked Dr. Forrest if Mr. Alexander received his first dose at 7 a.m. and simply if he was woken up 6 hours later, that would be 1 p.m. according to the math. I'm not asking based on a specific time again.
Okay. I'll allow it. You can continue.
Thank you, Thank you, Your Honor. And when he is woken up, Alexander says, and you believe he received a second dose of doxylamine, correct?
That's correct. Mr. Alexander recalled that after he was shaken awake, he was given a second dose.
And you know from Deputy Kim's statement that Mr. Alexander was awake the second time by 2:30 p.m., correct?
Yes, consistent with when Mr. Alexander dialed 911
All right,
at
now
2:45.
Objection, Your Honor, argumentative. This opposing counsel is cutting off the witness.
Okay. Yes, so let's let him finish his sentence first before you ask your next question. Okay?
Thank you.
Go ahead.
Now directing your attention to Exhibit D, you recognize this to be the 2 pieces of blue docking rope provided to you by Deputy Kim, correct?
That is correct.
And each of these ropes measure 3 feet in length?
Yes, 36 inches.
And based on your training and experience, doctor, you would agree that it is possible to bind one's own hands with a slip knot, correct?
It's possible to tie it, but untying yourself would be an issue.
But
That takes some Houdini-like skill.
But it's possible, correct?
Possible, but very difficult.
Thank you, Dr. Forrest. Your Honor, I have nothing further.
Go ahead on behalf of the people.
Yes, Your Honor. Doctor, why do you believe Taylor Alexander was given 2 doses?
Well, I believe that the first dose would be effective for around 6 hours if they were not roused awake prior, which was when the second dose was given, and that's consistent with the amounts I observed.
And just to be clear, Taylor Alexander was roused awake?
Yes, Mr. Alexander was.
Thank you. Your Honor, nothing further.
You can step down then. You're excused.
And Your Honor, before the people rest, we'd like to move Exhibits B and D into evidence.
Any objection?
No objection from the defense, Your Honor.
Exhibits B and D will be admitted.
And with that, the people rest, Your Honor.
Okay, thank you. On behalf of the defendant, your first witness.
Your Honor, the defense calls C.J. Costley to the stand.
C.J. Costley, please follow me. Please stand here. Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. And state your full name, spelling the last for the record.
CJ Costley, C-O-S-T-L-Y.
Go ahead, you can proceed.
Thank you. Good evening, Miss Costley.
Good evening.
What do you do for a living?
I'm CJ, I'm 27, and I'm the host of my podcast called Small Town Intrigue in Emerald Bend.
Okay, so tell us a bit about Small Town Intrigue.
Well, the hot topic in Emerald Bend right now is all about vacation rentals. In fact, that was the main issue of the election in November of 23. So my podcast is centered around the election, as well as other drama and criminal cases in the area.
Okay, so tell us about your coverage of the November 2023 election.
I mean, I've tried to attend every campaign event, and even met with both Harper and Taylor. And of course, I attended the November 11th debate.
Okay, and let's talk about the day of the debate. What happened that morning before the debate?
Earlier that morning, around 9:30, I went out to go get my newspaper, and that's when I saw Logan.
You saw Logan? What was she doing?
Well, she was putting a flower on my porch, which is kind of funny because she knows I'm covering the election. But yeah, we talked for about 10 minutes.
And moving on, tell us about the debate. How did that go?
It was supposed to start at noon, but Taylor never showed up.
So what direction did your podcast take after the debate?
At that point, I decided to re-listen to all my previous interviews, and it dawned on me how much animosity Taylor had towards both Harper and Logan.
Objection, Your Honor. Speculation as to Taylor Alexander having animosity towards Harper DeRay and the defendant.
Your Honor, may I be heard? Your Honor, I'm not asking Ms. Costley to testify outside of her personal knowledge. Ms. Costley has a podcast, and she has covered the election as well as interviewed both candidates.
May I be heard? Ms. Costley just testified that Taylor Alexander felt animosity towards Harper DeRay and the defendant. She cannot testify as to Mr. Alexander's mental state or the way he feels, and to do so is speculation.
Your Honor, may I be heard?
Go ahead.
Your Honor, Ms. Costley said that Taylor Alexander held animosity towards Ms. Gold, not felt.
At this time, I'm going to sustain the objection.
Move to strike that portion of the answer.
Yes.
Thank you.
Ms. Costley, did Taylor Alexander direct any comments to Ms. Gold?
She directed a lot of rude and nasty comments, saying, Harper DeRay is horrible for Emerald Bend, and so is their spouse, Logan Gold. Those two needed to be stopped.
And from your observations, did this animosity go both ways?
No, not at all. It was just tailored towards Harper and Logan.
Objection, Your Honor. Speculation on the same grounds as my last objection.
Your Honor, may be heard.
No, I'm going to overrule the objection, so you can go ahead.
All right, and switching gears, Ms. Costley, were there any other recordings you listened to while prepping your podcast?
Actually, yes. I came across an interview where I told Taylor to listen to my most recent podcast episode about the case of West Bethel and Crescent City.
West Bethel, can you remind the court who that is?
Well, I don't want to spoil it for you guys. It's actually about a guy who faked his own kidnapping.
Thank you, Ms. Costley. Your Honor, nothing further.
On behalf of the people?
Yes, Your Honor. May I proceed?
Yes, go ahead.
Good evening, Ms. Costley.
Good evening.
Now, I want to make something clear. On the morning of November 11th, when you spoke to the defendant, that was for only 5 to 10 minutes. Isn't that right?
On my porch, around 5 to 10 minutes, yes.
When the city council race started, you thought it would intrigue people, right?
I mean, I thought people would be interested in it, yeah.
Right, you thought there was a lot of captivating drama.
I believe so, yes.
So you started a podcast, right?
Yes, I did.
And in creating this podcast, you interviewed both candidates, right?
Both candidates, Harper, Logan, and Taylor, yes.
Right, and you grew to like Harper DeRay, right?
I did, yes.
And you grew to dislike Taylor Alexander, right?
Making it clear because of the nasty comments.
Right, but you disliked him, correct?
Because of the nasty comments.
Now, you also got to know the defendant, right?
Through the interviews, like I said, yes.
And you always liked the defendant, right?
Yeah. I thought she was funny, nice.
And you liked her, yes or no?
Yes.
Now, eventually, you supported Harper DeRay for city council, right?
Because of Taylor's nasty comments, yes.
Now, later, you learned that Taylor Alexander had been kidnapped, right?
I did. I was shocked, terrified, yeah.
You saw this as an opportunity, didn't you?
What do you mean?
You saw it as an opportunity to turn your podcast into one centered more on true crime, right?
I thought people would be interested in it.
So you saw it as an opportunity to center your podcast more on true crime, yes or no?
I mean, I saw an opportunity in it.
Objection, Your Honor, non-responsive.
Are you able to answer the question?
I
yes
can,
or no? If
yes.
you can.
Yes, I did.
You saw it as an opportunity to increase listenership, right?
At the time,
Right, so you took that opportunity, didn't you?
as a podcaster, I mean, who wouldn't?
And you benefited, right?
At the time, yes.
So Logan Gold's drama, it was good for business, wasn't it?
What do you mean?
Well, your viewership, it increased, didn't it?
Like I said, at the time, yes.
Thank you. Nothing further, Your Honor.
Any further?
Cross, Your Honor.
We have the defendant.
Oh, redirect. My apologies.
Yes, go ahead.
May I proceed?
Yes.
Ms. Costley, on cross-examination, you were asked about using Taylor Alexander's story as a business opportunity. Can you explain why you decided to share your thoughts on Taylor Alexander's story?
With the case of West Betha and this, I just saw so many obvious similarities that I decided to make a theory.
Objection, Your Honor. Inadmissible opinion. May I explain?
Go ahead.
Now, Ms. Costley has neither the expertise nor the foundation to give an opinion as to what she believed happened in this case. In fact, no one does, Your Honor. That's your job. So this is completely improper and inadmissible.
Your Honor, may it be heard?
Go ahead.
Your Honor, Ms. Costley, on her podcast, she has the case of West Betha, and she's saying that because she saw the similarities between Taylor Alexander's story and West Betha, she decided to use her story as a business opportunity.
I am going to overrule the objection, and the answer will stand.
Thank you, Ms. Costley. Your Honor, nothing further. May Ms. Costley please be excused?
Yes, you can sit down. Thank you.
And at this time, defense calls Harper Duray to the stand.
Harper Duray. Please follow me.
Yes.
The defense has 11 minutes and 36 seconds remaining for direct, while the prosecution has 7 minutes and 52 seconds left for cross.
Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. And state your full name, spelling the last for the record.
Harper Duray, D-O-R-A-I-S.
Your Honor, may I proceed?
Yes, go ahead.
Good evening, Mr. Duray.
Good evening.
Do you know Logan Gold?
Well, yes, she's my wife. Logan and I have been married for over 12 years, and we have a 2-year-old together. And, well, Logan was also the one who first encouraged me to run for city council in Emerald Bend.
You ran for city council? Was that in 2023?
The November election, yes.
And did you win that election, Mr. Duray?
I did, and now I'm honored to represent the people of Emerald Bend.
And your opponent in the election, Mr. Duray, who was that?
Well, my opponent was Taylor Alexander, and we did have some disagreements over important issues like tourism and vacation rentals.
So is it safe to say that you and Taylor didn't really get along?
Well, that's not the case at all. Even with the tensions of the campaign, there has been no personal animosity between us or our campaigns. Taylor's a good person. We just never saw eye to eye when it came to politics.
All right, and let's talk about your campaign. Were there any debates scheduled between you and Taylor?
Actually, there was supposed to be a debate on November 11th, just a few days before the election. Unfortunately, it didn't happen because Taylor never showed. So we called off the debate at around 1 p.m.
And did you ever find out why Taylor never showed?
Well, I know now that Taylor alleges that he was kidnapped.
All right, now let's talk about the morning of the debate. What was Logan doing?
That morning, Logan left me a note just on my bedside table, and the note said that she'd be out handing out flyers, but she'd be back before the debate started.
And did she meet you at the debate?
Logan was a bit late, but she arrived at around 12:30.
She was late. Was that typical?
Not at all, not for Logan. She's usually very conscientious, but she never wears a watch, and she did leave her phone at home that morning. I mean, I could just tell the stress was getting to her.
Objection, Your Honor. Speculation.
Your Honor, may I be heard?
No, I'm going to overrule the
Your Honor,
objection.
may I explain?
Go ahead.
Thank you. Now, Mr. DeRay never actually saw the defendant on the morning of November 11th, not until she arrived half an hour late at the debate. So he can make no observations of how the defendant seemed that morning. So to testify that she seemed anxious is completely speculative.
Your Honor, may I be heard? Your Honor, Mr. DeRay has been married to Miss Gold for over 12 years. He knew that a big debate was coming and that he knew his wife was stressed from this debate. Therefore, is not speculating that his wife was stressed.
Okay, I'm going to overrule the objection. Thank you both.
And what do you mean she looked stressed?
Well, when I saw her at the town hall, she looked frazzled but apologetic, but said that she was fine.
All right, and Mr. DeRay, let's talk about Logan. What kind of a person is she?
Logan's wonderful. She's supportive. She's the most kind and caring person I know. She's my rock.
All right, and after Logan's arrest, were you still able to talk with her?
Yes, at the police station.
Tell me about that.
Well, Deputy Kim took me to a room and I was able to sit next to Logan, but Deputy Kim was in the room as well.
And then what happened?
Deputy Kim stood just a few feet away from Logan with his hand on his gun and made a few comments to us, and personally, that made me very uncomfortable.
Okay, so what happened next?
Then Deputy Kim just placed his tape recorder out on the table.
Deputy Kim placed his tape recorder out on the table?
Yes, and I couldn't tell if it was on or not, and that made me very nervous. I could tell that Logan herself was upset and anxious, so we stopped talking and that was it.
Thank you, Mr. DeRay. Your Honor, nothing further.
Thank you. On behalf of the prosecution?
Yes, Your Honor. Good evening, Mr. DeRay.
Good evening.
I want to talk to you about a statement that your wife gave while in police custody.
Of course.
You went to the station that day, right?
I did, yes.
And there, the defendant made a statement about wanting to keep the inn in the family, right?
It was a lot of ramble, but I did hear a statement about that, yes.
And then you stopped her from speaking any further, right?
We wanted legal representation, so I did.
Now, it's the defendant that suggested you run for city council, right?
It wasn't my idea initially, so Logan was the one who first encouraged me.
Right, and then she served as your assistant campaign manager.
She was a huge help the entire process, Miss Packer, yes.
Without the defendant, you wouldn't have run, right?
Again, it wasn't my idea initially, so I wouldn't have ran without Logan.
And it's the defendant's passion for the campaign that makes you feel pressure, right?
I understood that my wife's passion was just the same as mine. It came for the help of Emerald
That's not
Ben.
what I asked you. It's your wife's passion for the campaign that makes you feel pressure, yes or no?
She's sometimes a bit much, but I understand where she's coming from.
Objection, Your Honor, non-responsive.
Are you able to answer the question?
I think I'm a bit confused on what the question is.
Why don't you re-ask the question?
Yes, your wife makes you feel pressure, yes or no?
Sometimes.
Now, heading into the debate, on November 11th, the race was neck and neck, correct?
It was pretty close, yes, counsel.
So, this was only 3 days before the election, wasn't it?
It was 3 days, yes.
So this was a crucial debate, wasn't it?
It was the last debate to convince any
So it was a
undecided
crucial
voters.
debate,
Yes.
right?
It was a crucial debate, yes.
You were extremely nervous, weren't you?
Well, public speaking isn't my strong suit, so I was extremely nervous, yes.
Now, on the morning of November 11th, you awoke at 9 a.m., right?
At 9, yes.
And at that point, the defendant was already gone, right?
I didn't see her that morning, no.
Wait, so you don't know what time she left, do you?
I couldn't tell you, I didn't see her.
Right, you were asleep.
I was asleep.
So you didn't see the defendant at 5:30 a.m.
Again, I couldn't tell you what time she left.
And you didn't see the defendant at 8:30 a.m.,
I
correct?
couldn't tell you, counsel, no.
You didn't see the defendant that day until 12:30, isn't that right?
At the town hall, yes.
And at that point, when she arrived at the town hall, Taylor Alexander was still missing.
I didn't see her, no.
Thank you. Nothing further, Your Honor.
On behalf of the defendant, go ahead.
No redirect, Your Honor. May Mr. DeRay please be excused?
Yes, you can sit down, sir.
Thank you.
On behalf of the defendant, you can call your next witness.
Yes, at this time, the defense calls Logan Golds to the stand.
Logan Gold. Please follow me.
Time remaining? Yes, go ahead.
The defense has 8 minutes and 43 seconds remaining for direct, while the prosecution has 5 minutes and 37 seconds remaining for cross.
Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. And state your full name, spelling the last for the record.
Logan Gold, G-O-L-D.
Your Honor, before I proceed, I ask that the bailiff place Exhibit A on the easel, please.
Yes, if you could do that, please.
May I proceed?
Yes, go ahead.
Now, Ms. Foltz, you've sat here in court all evening, and you've heard the prosecution accusing you of kidnapping Miss Alexander. So let me just ask you, did you kidnap Taylor Alexander?
No.
Objection, Your Honor, lack of foundation.
Your Honor, have you heard?
Go ahead.
Your Honor, as an offer of proof, I expect Miss Gold to testify that no, she did not kidnap Taylor Alexander. She would be testifying from what she knows, Your Honor. No foundation is necessary for Miss Gold to testify that she did not commit this kidnapping, which is the reason we're all here for, Your Honor.
Your Honor, this is the witness's first answer. I'd ask that foundation be laid so that we can properly assess Miss Gold's claims.
I'm going to overrule the objection, and you can go ahead and continue.
But no, I did not kidnap Taylor. I would never do something like that.
All right, so now let's talk about that morning, November 11th. How did your day start?
Well, that morning I was extremely anxious. I just needed to get out of my house and be productive, so I decided to pass out campaign flyers around the lake on people's porches. But I didn't leave my house till 8:30.
Before you left, did you tell your husband, Harper?
I did actually.
And
I left him a note.
Sorry. And while you were out by the lake, did you see anyone?
I actually ran into CJ while I was out there. But I thought it would make more sense to pass out campaign flyers near the town square so I can talk to anybody I run into about the campaign.
Your Honor, may Miss Gold approach Exhibit A?
Yes, go ahead.
Now, Miss Gold, how long have you lived in Emerald Bend?
My entire life.
Now, do you recognize what is depicted in Exhibit A?
I do. It is a map of the north side of Lake Ambrosia.
Now, using the map, can you show us the route you took into town?
Of course. So, CJ's house is here, and the main road into town is here. As you can see, it's very long and winding, but instead I took a shortcut here, towards Maple Fry Road. It's unpaved and not a lot of people know about it, so I believe it'll get me into town fast that morning.
Thank you, Miss Gold. You may resume your seat. Your Honor, at this time, the defense moves Exhibit A into evidence.
Any objection?
No objection, Your Honor.
Okay, Exhibit A is admitted then.
Thank you. Now, Miss Gold, did anything happen on your way into town?
Yes, my car broke down the Fry Road. And well, my car, she's pretty old. She's a 92, so I often have to do a lot of maintenance on her. So I have plenty of experience when it comes to fixing cars.
So were you able to fix your car?
It took me for like a couple hours, but yes, eventually I was able to fix it. But at this point, I knew I was going to be late to the debate, but I had no idea what time it was, and I couldn't even call Harper.
Why not?
Well, the clock in my car is broken, and I was so flustered that morning, I forgot my phone.
All right, so you were able to fix your car, and then what happened?
I rushed into town, but I didn't arrive until around 12:30, but the debate still hadn't started.
Did you see Harper?
I did. I was late, and I can tell he was flustered.
Did you say anything to him?
I believe it said something like, "I'm fine, it's all been taken care of."
And why did you say that, Miss Gold?
Well, I didn't want to get Harper more worked up. I just wanted to reassure him that the flyers that morning had been passed out and that I was okay.
All right, Miss Gold. Did anything happen after you spoke with Harper?
It was then that I found out Taylor still hadn't arrived.
All right, now shifting gears, Miss Gold, let's talk about the investigation. Did Deputy Kim speak with you?
She did speak with me.
And did the deputy tell you why you in particular were being interviewed?
When he spoke with me, he had mentioned a pillowcase from the Gold Standard Inn, which I own, was used in Taylor's kidnapping. And then he also mentioned a reference to my husband and I's campaign written on it.
Now, Miss Gold, who would have access to a pillowcase from your inn?
Oh, plenty of people. Employees, guests. In fact, a couple weeks prior to the debate, our inn was broken into, and plenty of things were stolen, including pillowcases.
Now, Ms. Gold, I have one last question. Do you have a catchphrase?
Sort of. I mean, I do say everything comes back around, but I do distinctly remember using it during my televised interviews.
Thank you, Ms. Gold. Your Honor, no further questions this time.
Cross-examination, Your Honor.
Yes, go ahead.
And before I proceed with cross, may I have a moment to arrange the exhibits?
Yes, go ahead.
Thank you. May I proceed?
Yes, go
Good evening.
Good evening.
Now, on November 11th, Deputy Kim told you about the gold standard and pillowcase involved in the kidnapping, didn't he?
When he spoke with me that morning, he had mentioned that, yes.
And your reaction was that you were being set up.
Well, yes, I did think that.
Your reaction was that someone was trying to frame your campaign, correct?
That was my first initial thought,
And that
yes.
someone was trying to frame you in particular, right?
The campaign, yes.
Now, back in November of 2023, vacation rentals posed a particular threat to you, didn't they?
It technically did eliminate business opportunities for the Gold Standard Inn.
Is that a yes?
That is a yes to your question.
And like you just said, it threatened to worsen your pre-existing financial struggles, didn't they?
We did have some problems due to COVID in 2020, but I believe all good businesses bounce back.
Now, on the day of the debate, you drove to the lake, right?
I canvassed the town and then I went to the lake, yes.
And you estimated it took you 30 minutes to get there, right?
It felt around 30 minutes.
So let me make sure I understand this. After driving half an hour to the lake, you only passed out 12 flyers?
I did only pass out 12 flyers. You do have that right.
And now I want to talk about your car. You told us it broke down on the fire day, right?
Since it's fairly old, it did break down.
And you claim you made a temporary fix to your starter relay. Do I have that right?
I did manage to fix a temporary fix, yes.
But despite it being temporary, you didn't buy a replacement on the day you broke down, did you?
No, since I did not want to be late to the debate.
Right, you waited 2 days later, didn't you?
I did wait to fix my car, yes.
So it was after police had questioned you. That's when you bought your replacement, right?
That is when I had time to find a replacement, yes.
And while we're on the topic of your car, you also managed to get oxalic acid all over your trunk, didn't you?
It did spill in the back of my car, yes.
Okay, you spilled it before you were arrested, right?
It spilled in the back of my car, yes.
Your Honor, may I approach?
Yes, go ahead.
Now, you recall buying boating supplies before the debate, right?
I did buy boating supplies before the debate.
And on November 16th, police confiscated a receipt for the purchase of those boating supplies, didn't they?
They did confiscate it, yes.
Now,
I do have
drawing your attention to what has been pre-marked as People's Exhibit E. You recognize this receipt as the receipt police confiscated, don't you?
Yes, this is a receipt I have made previously.
And right here, it says that you purchased blue line rope of 3/8-inch thickness, doesn't it?
In which I bought for my husband and I shared boat, yes.
And that purchase was on November 5th, wasn't it?
You do have that right. I did buy that on November 5th.
Thank you, Miss Gould. Your Honor, nothing further.
Your Honor, before I proceed with my redirect, I request a time check.
Time check, please.
You have 5 minutes and 8 seconds remaining for direct.
Thank you. Your Honor, may I proceed?
Yes.
Wait, 1 second, Your Honor. May we have a brief time check on behalf of the people as well?
Yes, go ahead.
1 minute, please.
Of course.
You have 2 minutes and 43 seconds remaining for cross.
Thank you.
Your Honor, may I proceed?
Yes, go ahead.
Now, Ms. Gold, on cross-examination, you were asked about spilling oxalic acid. Why did you have oxalic acid?
Well, my husband and I use it to clean our shared boat.
Now, Ms. Gold, on cross-examination, you were also asked about purchasing docking rope. Why did you make that purchase?
My husband and I use that for our shared boat.
Thank you, Ms. Gold. Your Honor, no further questions at this time. May Ms. Gold resume her seat at council table?
Yes, you can sit down, ma'am. Thank you.
Your Honor, at this time, the defense calls Dr. Cody Palmer to the stand.
Dr. Palmer?
Dr. Cody Palmer, please follow me.
And Your Honor, before I proceed, I ask that the bailiff display exhibits C and B on the easel.
Another time check.
Okay, time check, and then bailiff, if you could do C and D?
And B, Your Honor.
C and B, please.
The defense has 4 minutes and 49 seconds remaining for direct, while the prosecution has 2 minutes and 43 seconds remaining for cross.
Thank you.
Raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. And state your full name, spelling the last for the record.
Dr. Cody Palmer, Palmer.
Your Honor, may I proceed?
Yes, go ahead.
Good evening, Dr. Palmer. Can you tell the court what you do for a living?
Good evening, counsel. I'm a forensic investigator, and for the last 10 years, I have run my own forensic investigation consulting group. Previously, I was a deputy forensic investigator in a nearby county.
So, Doctor, what's your training and educational background?
I have an undergraduate degree in forensic science from Texas A&M and my medical degree from UNLV. I then completed a 6-year residency in forensic pathology at Las Vegas General Hospital, becoming a licensed pathologist.
So your expertise lies in all the areas of forensic science?
It does. As a forensic investigator, I stay up to date with all forensic techniques, taking supplementary training courses in a variety of forensic disciplines.
All right, now, Doctor, directing your attention to Exhibit C, what do we know for certain from the fact that Mr. Alexander has 160 nanograms of doxylamine in their system at 4:45 p.m.?
Well, his blood analysis alone tells us very little. For instance, the blood result doesn't tell us what time he took the medicine, how much he took, whether he took 1 or 2 doses, or whether he was forced to take it, or if he took it voluntarily.
Your Honor, may Dr. Palmer approach Exhibit B?
Yes, you can. Go ahead.
Directing your attention to Exhibit B, Doctor, do you recognize what's depicted in this exhibit?
Yes, it's a series of photographs. The top picture depicts Miss Gold's front passenger tire, taken 4 days after the incident, and the bottom pictures right here are of a tire track left at the top of Alexander's driveway.
All right, let's focus on the tread wear. In what way do you disagree with Dr. Forrest?
To begin with, I believe the pebble would have left many more impressions in the tire track. Yet, we only see one. Additionally, a single pebble in a tire is not unique to Miss Gold in a rural area like Emerald Bend.
All right, now focusing on the tread depth. In what way do you disagree with Dr. Forrest?
Well, Dr. Forrest and I both agreed that the tread depth of the tire track found at the scene is 5/32 of an inch. However, Dr. Forrest's measurement of the tread depth of Miss Gold's tire is inaccurate. The tread depth is actually 6/32 of an inch, which means Dr. Forrest's measurement is off by 1/32 of an inch.
1/32 of an inch? Really, Doctor? Is that significant?
Most definitely. A tire with a tread depth of 5/32 versus a tread depth of 6/32 would leave vastly different impressions.
So, Doctor, what is your conclusion in regards to the tire tread evidence?
There is no way to conclusively prove Miss Gold's tire is a match to the track found at the scene.
Thank you, Dr. Palmer. You may resume your seat. And finally, do you agree with the prosecution's forensic expert, Dr. Forrest, that it is possible to bind one's own hands or wrists with a slip knot?
Yes, on that point, we do agree.
Thank you, Dr. Palmer. Your Honor, I have nothing further.
On behalf of the prosecution?
Yes, Your Honor, and once again, may I have a moment to arrange the exhibits?
Yes, go ahead.
Thank you. May I proceed?
Yeah, go ahead.
Good evening, Doctor.
Good evening, counsel.
Now I want to speak to you about something that you had mentioned in your report, but you didn't mention on direct examination. Due to the dextromethorphan in Mr. Alexander's system, you call into question the clarity of his recollection, don't you?
Given the effects of dextromethorphan and the high amount of doxylamine, yes.
So let's discuss his recollection. Mr. Alexander reported that a pillowcase was placed over his head, didn't he?
At around 5:30, that is what he alleges.
And the pillowcase was recovered at the scene, wasn't it?
Well, yes, there was a pillowcase.
And then Mr. Alexander reported being bound with rope, didn't he?
Yes, in both his legs and ankles, I believe.
And rope was recovered at the scene, wasn't it?
There were 2 pieces of docking rope.
Exactly right. And ligature marks were discovered on the victim's wrists, weren't there?
There were ligature marks on Mr. Alexander's wrist, but not on their ankles nor legs.
And then Mr. Alexander reported that he was fed a high amount of a drug that made him fall unconscious, correct?
That drug would be doxylamine, yes.
And doctor, it's a fact that there was a high amount of doxylamine in Mr. Alexander's system, wasn't there?
Yes, that is correct.
Your Honor, may I approach?
Go ahead.
Now, you reviewed the tire tracks found at 1335 Lakeside Drive.
I had a chance to look at deputy's exhibit, the deputy Kim's exhibit, yes.
Right, and you'd agree that there's an imprint in the car's tire tread here, correct?
A tiny single imprint, yes, counsel.
And that's what Dr. Ray Forrest circled, correct?
Yes.
And you'd agree that that imprint is consistent with the pebble in the car's tire tread, correct?
Well, I don't believe it was that exact pebble.
But you agree it's consistent, correct?
It would be consistent.
Now I want to raise you a hypothetical question. Let's assume that there's a pebble in the ground right here. And assume further that a tire drives over that pebble. Are you with me so far?
Yes, I am.
Assume then the pebble gets pushed up deep enough into the tire tread so that it no longer sticks out past the outer edge. If all of those facts were true, you'd only expect to see that one initial impression, right?
Given that hypothetical, you would be on the right track, counsel.
Thank you, Doctor. Your Honor, nothing further.
Anything further?
Redirect, Your Honor.
Yes, go ahead.
Your Honor, may I proceed?
Yes, go ahead.
Dr. Palmer, on cross-examination, you were asked about the pebble found in Exhibit B. Are pebbles, such as the one we see in the exhibit, commonly found in rural areas like Emerald Bend?
Yes. Obviously, in a mountainous area, there'd be a lot of rocks, especially since 4 days had passed from the time of the incident to the investigation.
Thank you, Dr. Palmer. Your Honor, I have nothing further. May Dr. Palmer be excused?
Yes, you can sit down, sir.
And at this time, Your Honor, the defense rests.
Your Honor.
The prosecution, yes.
We'd like to move Exhibit E into evidence.
Exhibit E, any objection?
No objection from the defense, Your Honor.
Exhibit E will be admitted,
Thank you, Your Honor.
and both sides have now rested, correct, on behalf of the defendant?
Yes,
The
Your Honor.
prosecution?
Yes, Your Honor.
So this time we can go ahead and proceed to closing argument.
Yes.
On behalf of the prosecution, you'll go first.
Logan Gold was used to getting everything she wanted. When her family hotel was threatened, take a city council seat. When the election wasn't going their way, rig the crucial debate. And when she knew she'd be the first suspect in Taylor Alexander's kidnapping, manipulate the evidence to point so comically to her that she could claim, I've been framed. Now, the Gold Standard Inn was struggling financially, and Airbnbs weren't helping. The defendant's solution? The one open seat on city council, which would serve as the deciding vote on vacation rentals in Emerald Bend. So the defendant pressured her husband into running and became his assistant campaign manager. But the race was just too close. And it was all coming down to one crucial debate. But Harper struggled at public speaking. Too much was on the line. So the defendant made a plan to ensure that Harper would win. Because if Taylor Alexander never showed up, Taylor Alexander couldn't win. So on the morning of November 11th, the defendant went to Taylor Alexander's home. He had offhandedly told her that he goes for a run every morning at 5:30, not knowing that she would use that information to take advantage of him. And when Taylor Alexander stepped out of his home that morning, the defendant grabbed him, placed a pillowcase over his head, bound his arms, and shoved him into the trunk of her car. She then drove Taylor to his own vacation rental, where she dragged him down a muddy path and tied him to a metal chair. And in that helpless state, the defendant then drugged Taylor into unconsciousness. And sure, he would never make that final debate. Now you may be asking yourself, why would someone be so obvious as to leave behind a pillowcase from their own hotel or repeatedly use their own signature catchphrase? Well, as Mr. Beyond told you at the beginning of this trial, the defendant knew she'd be the first suspect. Now, this wasn't your typical kidnapping. Nothing was accomplished. No ransom, no theft, nothing, other than ensuring that Taylor Alexander never made that debate. Now, the defendant knew police would go straight to her, so she concocted a defense. Leave a series of over-the-top clues pointing directly at her. Because if the evidence so obviously points to Logan Gold, no one will possibly believe that Logan Gold was the one to do it. Now think about what you just heard during the defendant's own testimony. What was the first thing that she told police? I've been set up. I've been framed. And despite all this planning, the defendant made mistakes. You heard from Dr. Forrest that the tire tracks found outside the property where Taylor was held match the defendant's distinctive tire tread. And
2 minutes.
The defendant left behind Blue Dock Line rope she had admittedly purchased. And what was she forced to admit on cross-examination? That she just coincidentally spilled acid, eliminating evidence in her trunk. The very trunk where Taylor Alexander was held. Kidnapping under Penal Code Section 207 requires that the defendant take another person using force or fear and move that person a substantial distance. That is exactly what the defendant did to Taylor Alexander. And she grabbed him, bound him, forced him into the trunk of her car, and held him against his will for hours. The very definition of kidnapping.
1 minute.
Logan Gold tried to steal an election. She tried to rig a debate, and now she's trying to manufacture a defense. Don't let her plan work. Don't let her fool you. Find Logan Gold guilty.
Thank you. On behalf of the defendant.
Yes, Your Honor. May I proceed?
Yes, go ahead.
The November 2023 election, the open seat on the Emerald Bend City Council would determine not only the fate of short-term rentals in Emerald Bend, but the fate of Taylor Alexander's only source of income. As the court heard, Taylor purchased 2 homes with the intention of renting them out as short-term rentals. If Harper Dray made it on to the City Council, Taylor could say goodbye to that dream. Mr. DeRay campaigned on eliminating short-term rentals. Taylor either had to win the election or resort to more desperate measures. And as the facts in this case have shown, desperation breeds contempt. So, Taylor, driven by contempt, how'd she plan? Just like the fake kidnapping case of West Bethel, Taylor would fake his own kidnapping and frame the DeRay campaign. Taylor was just after the publicity and the sympathy of being a victim. So Taylor, the award-winning actor, played the part of victim
hoping it would win him the election. Now, because Taylor says his head was covered and his fake kidnapper disguised their voice, Taylor would never have to identify anyone. And of all places to take a kidnapped victim in a rural mountain area, it's awfully convenient that the fake kidnapper took Taylor to a property Taylor himself owned, and one that Taylor just happened to have the keys to on his person the whole time. Now, despite being overpowered while struggling with his assailant, forced into the trunk of a car, driven for an hour while in the trunk, dragged down a muddy hill, forced into and tied to a chair, Taylor suffered no injuries. Any reasonable person would expect to see a few cuts, scrapes on the knee, bumps or bruising. Taylor had none of that. Taylor's testimony of why he drank the unknown substance is simply unconvincing. His fake kidnapper forced a straw into his mouth and said, "Drink or there will be consequences?" What does that even mean? And then he drinks. Who would do that? How did Taylor know he wasn't about to drink battery acid or poison or God knows what? Now let's talk about that pillowcase. The use of a gold Standard Inn pillowcase with the words "Doré" for Emerald Bend written on it is straight out of a low-budget, poorly written suspense film. Even the most foolish person would know not to use anything that would lead back to them. I mean, think about what Taylor is asking you to believe, Your Honor, that Miss Gold would go through the trouble of covering Taylor's head and disguising her voice so as not to be identified, but then use a pillowcase from her own inn and write "Doré" for Emerald Bend on it? That's not only unbelievable, it's laughable. The only conclusion you can draw from the pillowcase is that Taylor Alexander, in his role as victim, was trying to frame the Doré campaign. And on top of all that, the people have lost the pillowcase. Now let's move to the tire treads. The people's tire tread analysis is flawed. The prosecution's expert, Dr. Forrest's measurements are incorrect and off by 1/32 of an inch. Couple that with the fact that a pebble in the tread of a vehicle in a rural mountain area with unpaved roads is not unique to Miss Gold. Simply put, the tread and track analysis actually excludes Miss Gold as a suspect. Turning to Exhibit D, the two pieces of rope measuring 3 feet each. Taylor testified that his hands were tied behind his back and to the chair, and that each of his legs were tied to the chair. But it would have taken 3 ropes to tie Taylor's hands and both of his legs to the chair, yet there were only 2 ropes found at the scene. Your Honor, Miss Gold told you where she was and what she was doing the morning of the debate. She was nowhere near Taylor, as corroborated by C.J. Costley and Deputy Kim. She was passing flyers out to the homes on the lake. Finally, as Mr. Doré told you, Miss Gold is kind, caring, and supportive, all character traits inconsistent with the violent kidnapping. And as the court knows, that alone is enough for reasonable doubt. Your Honor, if the evidence showed anything tonight, it's that Taylor Alexander, in his desperation to win the election and save his only means of income, faked his own kidnapping in an attempt to frame Logan Gold. Your Honor, find the only verdict supported by the evidence. Find Logan Gold not guilty. Thank you, Your Honor.
Thank you. On behalf of the people?
Yes, Your Honor. May I proceed?
Yes, go ahead.
Now, the defense wants you to believe that the defendant has an alibi, but the kidnapping took place over 9 hours. C.J. Costley saw the defendant for 5 to 10 minutes, 4 hours after Taylor had already been abducted from his home. Now, a brief meeting that accounts for 2% of the morning, that's no alibi. Now, they want you to believe that Taylor Alexander staged his own kidnapping. Your Honor, the physical evidence supports his testimony. It was the defendant, not Taylor Alexander, that had blue dock line rope. It was the defendant, not Taylor Alexander, whose tire tracks were found outside the property. It was the defendant, not Taylor Alexander, who spilled acid everywhere. Your Honor, it was the defendant. Find Logan Gold guilty.
On behalf of the defendant?
Yes, Your Honor. Before I proceed, may the bailiff display Exhibit C on the easel?
Yes, if we can have Exhibit C, please.
Yes,
May I proceed?
Yes, go ahead.
The prosecution must prove to you beyond a reasonable doubt that each fact they rely on is true. To meet this burden, they bring you the unbelievable testimony of Taylor Alexander and a kidnap plan devised by an award-winning actor, the speculation-filled testimony of Dr. Forrest, the toxicology results that actually mean nothing, 2 ropes when there should be 3, and the complete lack of motive for Miss Gold to commit this crime. On the other hand, the defense has demonstrated that Taylor had a very strong motive to fake his own kidnapping and pin it on the DeRay campaign. Miss Gold was nowhere near Taylor, as corroborated by C.J. Crossley, Harper DeRay, and Deputy Kim. Dr. Palmer convincingly demonstrated that the tire tracks out at the scene actually exclude Miss Gold as a suspect. And finally, Miss Gold is kind, caring, and supportive, all character traits inconsistent with a violent kidnapping. Find Logan Gold not guilty. Thank you, Your Honor.
Thank you. Okay, at this time, I want to give a round of applause. And this will start the protest period, so if you want to confer your coaches.
There's nothing from the people, Your Honor.
Okay.
Nothing from the defense, Your Honor.
Okay. Then give us a time now to complete some paperwork, and then I'll come back in a second. Are we all ready? Come to order. So at this time, in the case of People v. Gold, having considered all the evidence, hearing all the witnesses, listened to all the opening, closing statements, at this time, the court is going to find the defendant not guilty. And so, at this time, I'll go ahead and move on to have each team select an MVP from the other team. Are we doing that?
Your Honor, during the final round, we don't
do that. Okay. You all are like, oh, we have to do that? Okay, if we don't do that in the final round, we won't do that. No, I was just following a script. If you all don't do that in the final round, I'm good. So,
Yeah, we're good to go.
We would like to award the MVP award to Ms. Packard.
Thanks. And we'd like to give our MVP to Miss Kramer.
Well, this time I'm going to introduce myself. My name is Judge Sykes. I was a state court judge here for about 10 years, sitting just down the hall in Department 6, running unlimited civil trials, and also the complex department. I, in 2022, was appointed by President Biden to the Central District of California District Court. So I'm a federal district court judge just down the street here in Riverside. I'm also a member of the Navajo Nation, originally from Arizona, Tuba City, Arizona, the Cody Pass Maideshkiznik clan. So I'm the first Native American to be appointed to the district court in the state of California. So. And I just want to say that you all were amazing, having been both sitting in state court and federal court. And I know you all have heard this so many times, but you are amazing, and just the poise that you each have. You know, it's not easy to get up here as witnesses, as attorneys, having to answer questions that I fielded to each of you during the pretrial argument. You all really handled yourselves with dignity and grace, and you obviously knew the law in the pretrial questions. I asked you a little bit of some hard questions, I thought, and you were able to answer those questions exceedingly well, and then also be able to pivot back to your script And I know that it's oftentimes very hard, even as attorneys, to be, peppered with questions and then kind of remember where you were. So I think each of the pretrial attorneys did an excellent job. I thought the witnesses as well did an excellent job. I love the way you acted, and you had your own little attitudes, and your, everything about the witnesses was great. And then just the attorneys, being able to respond to the objections. When I gave you the opportunity to argue your case, you were able to do that and be able to assist me in making those decisions. So I think you all did a wonderful job. So you should be very proud of yourselves, as I am. So, and before I let the judges introduce themselves, or the attorneys, scoring attorneys and judges in the box here, I just want to recognize the coaches, because I know it takes a lot of time and effort that you put in and volunteer to teach these students and to work with them. I also want to thank the teachers and your family and friends, because I know participating in mock trial is essentially like participating in a sport, a mental sport. So it takes a lot of time, effort, and so I just want to thank, first I want to thank the coaches. Who are the coaches? Are there any coaches in here? And also any teachers or family and friends. Let's go ahead and thank all of you. I look forward to seeing all of you sometime in the future if you all are interested in legal careers, which I expect some of you may be. So it's a great career. As an attorney, as a judge, working in the legal field, there's so many opportunities for you, so many things you can do, not only to help the community, but help the state, help our country. So I do hope to see you all sometime in the future, perhaps even in my courtroom in the federal court. So congratulations again to you all. Let's go ahead and do another pause. And let's go ahead and have those judges and attorneys in the box introduce themselves.
Hi, I'm Jacqueline Jackson. I'm currently the presiding judge of Riverside County. I just started that job in January. Previously, I've sat in probate, criminal, unlimited civil, and juvenile. Sounds like I can't keep a job, because they were all very deep jobs. I was appointed by Governor Schwarzenegger. So a while ago, this is year 15 for me. I've seen a lot of attorneys and all of those assignments I just mentioned, and you guys could go toe-to-toe with any of them. Fabulous job to me.
Good evening, everyone. My name is Megan Dembski. I'm the president-elect of the Riverside County Bar Association, and I'm the managing partner of Aiken Cone in Riverside. And I graduated a local high school, which will currently remain anonymous, in 2009. I left for undergrad and law school, and I came back, and kind of my message to you all tonight is, and hopefully if you decide to become a lawyer, please think about coming back. This is a fantastic legal community. It's supportive, it's nurturing. We wrap our arms around each other, and I couldn't have thought, this is my 10th year of practice, and I could not have imagined a better, more supportive community to be a part of. And congratulations to all of you tonight.
Good evening, my name is Steve Harmon. I'm the public defender of Riverside County, and I thought tonight's trial was thrilling. It was just thrilling. One team is going to win, one team is going to lose, and that is just a shame. But that's the way it is in real trials. One lawyer walks out winning, another lawyer walks out losing. I always tell my lawyers, I don't care if you win or lose, but I do care if you did your best. And so you all did your best tonight. We could see that. And I know it's going to be painful for the team that doesn't win. It's going to be thrilling for the team that wins. But you all are winners. You all did your best. Your parents and your friends, your families are all going to be so proud. And I've been with mock trial for many years. I can tell you, you'll never forget what you did tonight.
Good evening. My name is Virginia Blumenthal. I was the first girl attorney to break through in Riverside County and the first woman-owned law firm in the Inland Empire, which all says that I'm old. You guys were amazing, and I want to tell you, Steve Harmon was one of the best trial attorneys, criminal defense trial attorneys I've ever seen, because he and I tried a lot of cases together, and were co-counseling with both the same defendant and different ones. He also coached mock trial. I saw how he coached his teams and what he did, and he did it for many years. I helped to bring the mock trial program to Riverside County. And so we're talking like 40 years ago or more. And you guys were amazing. I love the development. I could talk about every one of you as to the qualities. It was incredible. And Mr. Harmon is correct. A team's going to win, a team's going to lose, but you're not losing. It's just you're not getting as high of points. Both teams are total winners. And I compliment you. I compliment the coaches. You have been incredible with the students that you have developed and the skills that you have developed within these students. I coached long enough that I know that. I want to congratulate you, and I want to thank you so much for giving to your school, your community, and to your team.
Good evening. My name is John Aki. I'm the Chief Assistant District Attorney. I run the day-to-day operations of our 900-person law firm for the Riverside County District Attorney's Office. I talk to our district attorneys on a daily basis. We train them. We bring them up in the courtroom. I get to see them perform. By far, you have been one of the most amazing classes I've ever seen. All of you, from the witnesses to our pretrial attorneys to all of our attorneys. In fact, I'm prepared to offer all of the attorneys a job. That's how good you were. Amazing job, well prepared. Fantastic job to the coaches and teachers who coach these kids. I can't say enough great things about them. Thank you so much.
Are we ready?
Absolutely.
Okay. You sure you want to know? You guys want to talk some more?
Okay, because I can see you're all crawling out of your skin to hear the results, I'm not going to give them right now. I know. So this program, it's put on by the Riverside County Office of Education. There are 3 women that worked with us all year to make sure that everything ran smoothly. I've been passing out things to them as we go along, but I haven't given anything to Yadira yet. So we wanted Yadira Chavez. Come on. Ryan favorite. She grabbed her card so she wouldn't come up here, but this woman, if your coach maybe sends an email saying, why is the world unfair and why did the world not turn my way, she has to answer it. She has to put together all of this. She gets there about an hour before anybody walks through the door. We can't do this without her, so thank you. In addition to the Office of Education, we have a steering committee that is made up of local attorneys and also local judges. And one has told us he's going to leave the steering committee, and so he said he'll still judge. So can I get that right? Still judge? Yes, okay. He said yes. But I wanted to just recognize Chad Firetab for what he's done to the program. This is a mock trial kid who was actually coached by Steve Harmon. And I learned tonight he met his wife in mock trial in 1994. And so, we have what connections? I even have a mock trial student, 2 mock trial students who got married and are still married. So just know love is in the air. But no, we wanted to thank Judge Chad Feiertag for the time he has given not only as a competitor, as a scorer, as a consistent member of the steering committee. He is the one who wrangles judges. And if you think getting attorneys to do things is hard, try to get a judge to show up on a Saturday and score a mock trial. And he's done that for us consistently. So if you could just give a round of applause. Okay, last talkie, but you're gonna like this one. We talked after Blue Ribbon, and we said, isn't it weird that we give out all these awards before the thing's even done? Yes, the first 4 rounds are intense, and a lot of different people get to be seen, and we want everyone in the program to be recognized. But the Riverside County Deputy District Attorneys Association decided they would like to give an award for finals. So when you saw the scoring attorneys go back into chambers, they were not deciding the result. They had already turned it in. It was already done. They were talking about an award that the DA's Association wanted to give. And they're calling it Best Advocate. The only rules I gave them was it's got to be a pretrial attorney or a prosecution attorney or a defense attorney. Don't care if you think their team won or not. I just want you to say this person in this final round was the shining star advocate. And the District Attorneys Association is going to give this individual $500. So all these very smart folks met, and they have asked that we honor, as Best Advocate of this final round, Jonathan Bienick. Without further ado, I know Judge Hale likes to talk. No. You want to do this? I'm going to announce the winner because I think that's always best to do first and get it out of the way. And then I'm going to invite up the second place team to accept their medals and their trophy. The winner of the 2025 mock trial finals of Riverside County is Pauley High School.
Yeah.